of the Human Services Committee to order at 7:24 p.m. The meeting is called to order. May I have, I'll do the roll call. Councilmember Heracles. Councilmember Ravel.
Here.
Councilmember Burns.
Here.
Councilmember Braithwaite is here, but in the Aldermanic Library. Councilmember Reed, myself, is here. We have a quorum. First, may I have a motion to approve the minutes of the May 2nd meeting?
So moved.
Moved by Councilmember Ravel, seconded
Second.
by Councilmember Burns. All those in favor of approving the minutes, say aye.
Aye.
All those opposed, any abstentions? The minutes pass. That brings us to public comment. We have,
There's two online, and here is one that emailed.
okay, we have,
This is Head Online.
let's start, we'll start with the person that is in person, and that is John Herbert.
John Hebert.
Hebert, sorry.
That's okay. I just have some concerns about an article that I read about some of the proposals that Alderman Reed has put forth regarding the opening of the parks for 24 hours, the fact that burglary tools, you can tell me if this is incorrect or not, but their burglary tools would no longer be illegal to possess, that children, I guess, or underage people will be able to buy liquor and not have any, or would attempt to buy liquor and would have no consequences. Maybe nobody called their parents or whatever it is. I just think that some of these proposals are sort of, with all due respect, sort of immature. And I would hope that somebody could touch on some of these questions that I've raised. And if you could tell me if they're correct or not. Like I said, this was in an article my wife gave me. And so, I'm just concerned about, I just moved from Hyde Park to Evanston. And I moved from Hyde Park out of Chicago because of the schools, because I think that the city's being sort of mismanaged. And I am concerned before buying a house or something like that here, that we're not headed down that same path. And that's what I have to say.
Thank you. With public comment, we don't traditionally respond, but I am hoping that you stick around and watch the meeting, because all of your answers, or all of your questions will be answered. And also, I will provide my personal contact information to you, so we can have a conversation. Great. Okay, so that brings us to folks who are signed up online. And let's start with I think there are 2 people signed up online.
Yes.
And I'll just wait for the names 1 second. If you're online and you're signed up and you would like to speak, please unmute yourself and declare your name. Ms. Russell, hello.
Hello, can you hear me?
Yes, we can hear you.
Okay, I don't think my camera is working, but it doesn't matter. So, I'm strongly opposed to Revel's Ordinance 19-022, as it no longer considers a public nuisance any loud, unnecessary, or unusual noise which annoys a reasonable person and disturbs, injures, or endangers the comfort, health, peace, or safety of Everstonians. Tell me, if the ordinance passes, would I have then a legal right to bang on a drum, play the trumpet, or yell outside of a residence? And if so, could I do it at night too? The issue of noise is paramount to me. Whereas I oppose 19-022, I do support Alderman Reed's Ordinance 59-022, modifying portions of the City Code 710-2, Parks, Hours, and Operation, since it lowers the time for noise in the park from 11 p.m. to 10 p.m., while allowing rightful quiet enjoyment of parks at all times. I do not believe it would increase disturbances in the park, since park disturbances are largely caused by people not aware of the rules and rarely by those who would disturb the peace, irrespective of any type of regulations anyway. I want to make clear that park noise issues after hours have been a personal issue for me and neighbors whose homes face McCullough Park. Since the park's renovation, there has been a substantial uptick in young people descending on the now new and unfortunately too brightly lit basketball court. They don't do so out of malice, but because they're not clearly aware of the rules. I'm forced to leave my bed several times a week to point out the hours of operation listed on the park sign to the noisemakers. Once they read the sign, the kids leave. But the sign should have been placed on the court itself, where it would be clearly legible. I believe an improvement in communication will go a long way to reduce these nightly incursions. The city should therefore publish on the site what the rules are for curfews, park, courts, and playground hours, and additionally produce flyers, just like they did for recycling rules. Broadcasting this information would encourage compliance of the rules, or at least make parents aware of them, and hopefully they might communicate these rules to the kids. At present, no police patrols McCullough Park. In the past, I would call them, but it would require several calls before they would even show up. I'm concerned about confronting some trigger-happy youth, but if I want to sleep at night, I have no choice but go out and talk to the noisemakers. Please help residents living next to parks and courts by publicizing the rules for hours of operations within. I also approve of most of the other ordinances that Devon Reed wants to pass because they, in the name of equity and safeguarding minorities' rights. However, the only one I'm against is 55022, throwing stones and small objects. From personal great damage occurred to me somebody threw an object at me and I required 10 stitches. It wasn't a large object, and I don't think that throwing stones at cars or people or buildings is a good idea. So I don't understand the rationale for that, but maybe Alderman Devon can explain it. But the other ones, yes, if you're going to have an ordinance against showing breasts, then it should be before men and women alike. There should be no difference. Thank you.
Thank you. That brings us to our next public commenter, Doreen Price. If Ms. Price is not on the call, then we will go to Betty Esther. Ms. Esther? If Ms. Esther is also not on the call, then we will come back to Ms. Price and Ms. Esther at a later point if they choose to provide public comment. And we will move on with our agenda. That will bring us to item... and I will note that there was a comment received by Robert Bush relating to ordinance 59022, discussing the park issue. And this can be forwarded to members of the council and be put on the record. Okay, thank you very much. That'll move us to our first order of business. We will bring the Environment Board up, but first I just want to deal with item HS2, Resolution 38R22, approval of an honorary street sign name designation for Joanne Avery. Is there a motion? So moved by Councilmember Revelle, seconded by Councilmember Burns. I'll just say that this is a great honor that Miss Avery, this will come to council and I'll say what I have to say then, but Miss Avery has touched so many folks, touched the lives of so many folks in the Black community, particularly in the Fifth Ward. My mother was someone who went to Miss Avery's programs, and so many other children across our city have also been touched by her great work. So this is a great honor for her. Okay. Is there any more discussion on that? Seeing none, all those in favor say aye. All those opposed? I see Councilmember Braithwaite said aye as well on the Joanne Avery Way. Okay, that passes unanimously. I'm going to I'm going to allow public comment because I do see that Betty Esther and Doreen Price are here. So Doreen Price, you may go.
Yes, thank you very much, and we'll get this to work eventually, right? Smile, everybody. You've had a hard preceding few hours, and I admire the people who are fighting for all the good stuff for the rest of us, so thank you. So this has to do with HS3, and it's really personal, and it's really important. And there's so much that can go wrong if you have people, which has been discussed, misapply the law. And in this case, I was in an emergency where my emergency generator was critical. It was also the pride and joy of the project leader who was fearful that anything should happen to it. This was state of the art, which means you could have it inside your house. At the time to dry down my house after the flooding, I had fans like crazy. They didn't have enough fans initially. They were trying to get enough power to my house to dry down my house, and it was delayed in terms of not having at the time a fire engine who had the ability to take water away. That has since improved, which is I advocated for, because if you go through something like that, you don't want it to happen to anyone else. And I advocate from the heart that way, as many of you hopefully know. And so for this, I want to say, please, all emergency equipment that's needed to rescue or restore residents and their homes must be protected from interference, and I mean interference, because there was no ethical and moral reason. Plus, I own my property, and and I own the easement around it, or co-own it, and share it with people who take it. In terms of, that's another issue that zoning needs to look at. Neighbors who take over other people's property and for some reason, it's not caught. So anyway, from my heart, I'm pleading that we listen to residents, we listen to their information. If it differs from what you know, please investigate it and explore it and back up the people going through a trauma
Thank-
especially. That really hurt me a whole bunch and still does, as you can tell. Trauma is trauma, and City of Evanston has it, and we should be more compassionate as a result of it. And I've met the most amazing people because of sharing that and having something like that in common. But it would be much easier if we could listen to the residents in all matters, even right now where it's difficult, and having discussions. And it's those discussions I congratulate and thank you, because they are difficult when everyone is being honest. And being honest isn't always easy to self-reveal when things have gone wrong for you and you can't explain it. So just be open and honest about what's going on, and I think we'll all do a lot better in our manager search. So anyway, a little bit long, but basically everybody has to count, and when you're in an emergency, you're not counting. It's the worst thing in the world, and there's more emergencies that happen to people, and to not be heard or listened to because you have an ordinance that allows someone to do something and misapply it. We have to stop that. And so we need a neighbor abuse
Thank you,
policy
Ms.
too
Price. I'm
eventually.
going to have to ask you to wrap up.
Okay. In terms of the other thing for future discussion,
Oh,
let's to talk about a neighbor abuse policy or a neighbor ordinance policy to prevent abuse. Anyway, with that, I say thank you for the extra sentence. Thank you.
Thank you. Last on the list is Betty Esther. Is Betty Esther in the call yet, or are we still? Okay. Given that, if Ms. Esther does appear.
There.
Oh,
Yeah,
There we
I'm
go.
unmuted now. Thanks. Looking at the agenda and everything, and we have the obedience of the police in public place, and you're changing this. And my question is, with ordinance that deals with where people are in everything, why are these ordinances not discussed with the public so the public will know what you are proposing, or if they think that this law would be totally wrong? There is no public conversation or dialogue about this ordinance. So it should not be up for voting. It should be up setting up where you have community meetings around this ordinance. So I ask you, please, have the community meetings first and then come back and vote on it. Thank you.
Thank you.
That's ordinance 56022.
Thank you very much. Thank you, Ms. Esther. And a lot of folks in democracy would say that this is the community discussion and where folks get to weigh in and share their opinions. And we will get to that work now. So continuing on
No, it's not.
Thank you. Continuing on with the agenda, we are going to move the next item will be the HS12 Environment Board report, since we have folks who are going to be updating us on this. And this is simply to accept and place on file. So I'll ask for pretty much the high level report on this, and it was available for all of us to read.
Yes.
Is there someone here from the Environment Board?
They should be online.
Yes.
There you go.
Hello.
Shall I go ahead?
Yes.
Yeah. Hi, good evening. Thanks so much for making time. I know you have an extremely long agenda still ahead of you, and it's late right now. So we'll be very, very brief. And thanks to Kara Pratt for being here as well. She's the primary staff liaison with the Environment Board, along with Brian Zimmerman. So according to the code, the Human Services Committee is the committee to which the Environment Board reports, but it's been a little while. So we wanted to catch up and just gave you that memo in your packet that's briefly what some of the things we've been working on lately and have before us. Just to kind of let you know, there are 11 members of the Environment Board, and at the moment we have members from 7 boards, and they include a former EPA official, director of sustainability for a corporation, software engineer who does greenhouse gas accounting work, a social scientist with the Forest Service, and people with backgrounds in natural resource management, communication, education, and so on. So our role is, we understand it, is to provide research and advice for you in your policymaking work, and also one of the main channels for public engagement around some of these issues. And as you know, in recent years, climate action has been our #1 focus, and we thank you for having adopted the emergency declaration recently. So as we mentioned in this memo, one of our follow-on activities there is working closely with Kara and other staff to increase public engagement and awareness of our climate action plans, and including development of a climate dashboard for reporting. The one other thing I will call attention to is that the tree protection ordinance, we've provided advice recently to the Planning and Development Committee at its request, and part of that memo was background was in the packet as well. The climate, I will just say, because of the topic of the main focus of human services being public health, we focus on both climate mitigation and climate resilience. And resilience is really a public health matter, and that includes trees. We are suggesting in our recommendations that we provided to planning and development, modeling what we do after the city of Cambridge, Massachusetts, which explains very, very well that is a public health matter, primarily around heat and heat island effect. So I'll just wrap up there, but we thank you very much for your support. We're happy to report at any time or follow up with you. And I don't know whether Kara Pratt wanted to say something as well, but I will stop there. Thank you so much.
Thank you, Ms. Pollock, and always happy to have an eighth warder, right, on any committee and presenting here. Am I incorrect in that? Am I misremembering that you're an eighth warder? Oh, you're muted.
Jerry Garl is your constituent. She heads the Climate Action Task Force.
I know, yeah, I know
and,
Jerry.
I'm Ward 4.
Okay, sorry.
Thank you. Thanks.
Okay, are there any questions from the committee? Councilmember Ravel.
It's not a
Or
question.
comments.
It's a comment. I'm particularly grateful for this extended memo about what we should be considering for a tree protection ordinance, because that is something that's coming back to us very soon that we really need to be able to move forward. So I think this is going to be very helpful. And I'm delighted that the Environment Board is working on several other really important issues for us as well.
Thank you. Are there any other comments? Okay, with that, thank you, Ms. Pollock of the 4th Ward, and thank you to the full Environment Board team, including Kara, for all of your work on this. With that, can I have a vote? All those in favor of accepting and placing this report on file, say aye. Aye. All those opposed? Any abstentions? It passes unanimously. Great. That brings us on to the next item on our agenda, which is Ordinance 19022, amending portions of the City Code 9520, noises prohibited, and City Code 831A, enumeration of particular nuisances. Is there a motion?
I move approval.
Councilmember Ravel moves approval. Councilmember Heracades seconds. Councilmember Ravel.
Okay. Well, this is something that you all have seen before. It's been amended one more time, which is to specify a decibel limit that would be measured at the property line of the property where the sound is being disseminated. And so I hope that is a measurement that strikes people as both something that's enforceable and understandable and makes sense in terms of the sound level that is set. We had a little, Councilmember Burns came out for a sound test the other day over at Canal Shores, and we had the loudspeakers going at 75 dBs at the Canal Shores patio, and then we walked away a certain distance, and it was, certainly acceptable for the residents when we got farther away, and yet 75 dBs at the patio itself was, considerable, a good musical experience, I would think, for the people on the patio. So I think that I think that's a good decibel limit for us.
Thank you, Councilmember Ravel. Whoever beats, they simultaneously almost. Councilmember Heracades.
So I did an unofficial test at my house because of I like to when I grill out, I like to listen to my stereo outside, and I turned my stereo up and checked at the decibel reading, and at the loudest I would ever play it was 80 decibels, like right at the speakers, and it was, by the time it got to my property line, it was well below that, and I think it's a totally reasonable decibel level, and should work out for everyone, and should not be something that can easily be, used against people. So I support it.
Thank you, Councilmember Burns.
Councilmember Hadikadis, his testimony provided some clarity, because we tested from the property line, but the residential property was much further than the neighbor next door. And so my question was, how does this, how does this protect, in residential, dense residential areas? And so, you tested it, and I don't know if you have a comment on that as well.
Right. Well, I heard from Councilmember Heracades about his sound test, and it seems to me that the part of the code that's actually not anything we've been looking at would be what would apply to the situation for someone displaying basically a loudspeaker with their home sound system just in their backyard. And so so that we've been dealing with subsection F of the whole gigantic noise prohibited part of the code. Then there's a section G, which deals more with what I would consider home backyard gatherings, not something that we've been talking about with loudspeakers in subsection F. And
Sorry, point of
So-
information. I'm looking at subsection G,
right,
and it says the presence of bushes, weeds. Are we,
of the noise ordinance.
yeah,
So say that again?
I'm looking at subsection G, and it says the presence of bushes, weeds.
No. If you have to be looking at Title IX, Public Safety, Chapter 5, General Offenses. If you can find the subsection F.
I'm sorry, this is separate from what's in the packet that you're.
Right,
Okay,
right,
my
yeah.
apologies.
So subsection G talks about radios and phonographs. And it sounds more like what you might be doing in your backyard, as opposed to a loudspeaker on a patio with an audience. So that's I'm trying to answer Councilmember Burns' question about what happens in a residence.
Yeah, and I think what's confusing is if you look at the current code under F, loudspeakers, amplifiers, paging systems, under number 2, it talks about location within 150 feet of residential zone property.
And that's what we're changing.
Okay, but it's still, unless I'm seeing that wrong, under F3, it says, now I'm going under the changed version, it still includes F1. It says restrictions upon hours of permitted use, no machine or device specified in subsection F1. Is that just a typo? Is that not supposed to be there any longer? Because we don't have a F1 any longer?
F1 we're not making any changes to. That's if you're using a loudspeaker for advertising purposes.
F1 was just not included in the draft of the ordinance in the
Right.
packet, but
Okay.
it's not being changed, it's still there.
Okay.
Right.
And F2 still talks about location within 150
Well,
feet.
but that's the part that we're changing.
We're striking that, okay.
Right.
Um,
We're
It's confusing because F and G really both talk about outdoor noise.
I know,
Yeah.
and I the
I wish
more
there
the
was a
more
way we could-
the more I work on this thing, the more frustrating it gets because it gets more and more unclear. I'm not really, and what I think is really strange is in section G, radios and phonographs, it says if you're going to do any of this, you need a permit. Well, we never ask anybody to get a permit to play their phonograph in their backyard. So, I mean, I think we need to revise that too.
Yeah, I guess between, this meeting and the next meeting, I'm happy, moving along to continue to work on it. I think we need to find a way to really bring G and F together because it really is speaking to the same issue, which is outdoor noise. And it's overly complicated at this point. And then once we do that, I think we're in that discussion, we need to really determine, and then some other questions I have is 75 dB, so as long as you're not over that, it doesn't require any permit, not a special event permit, not a...
No, well, no, and the reason F and G do need to be separate, but maybe better defined, is
Yeah.
because section F really addresses using a loudspeaker in a setting where you're trying to entertain groups of people. So think about, special event concerts, and those are the kinds of things, and events at Fountain Square, for example, they get a loudspeaker permit. So, whereas G would be the more informal, having a bunch of friends over and playing music in your backyard, you don't want to have get a permit, and I guess the question is, you know,
Well, G does require a permit. We don't.
it does,
yeah,
it
we
does
don't-
currently,
and I
which,
think it should.
which,
And that's why I think we should
well,
put it
I-
together
but
because.
I- no, but
yeah, sorry, go
but
ahead.
we don't want to have to make, if you want to play your, you know, some music in your backyard with a group of friends, we don't want you to have to go get a permit.
Absolutely not, right. Up to a certain, up to a certain decibel level.
Well, but if you're well, because we've already said you can't have a special, you can't have a loudspeaker permit issued if you're within 150 feet of a residence. So we're already saying that the loudspeaker permit is really only applicable in places where you're going to be 150 feet away from a residence.
And so I guess what I'm saying is just 75 dB, is that going to require, in any respect, will that require any permit?
The thing that requires the permit is using the loudspeaker. And the rule when you use your loudspeaker is that it shouldn't be more than 75 dBs. The thing that sets off the need for a permit is the use of the loudspeaker itself.
See, and I think that's flawed because you could have a loudspeaker down at a reasonable level in your backyard. And
Right,
not
and
disturb the peace or-
that's section G. Because you're not trying to entertain a big group of people.
Point of information, and,
Sure.
and I hear, just to cut through, because I hear what both of you are saying, and I want to, let me look back at the code to get this right, because just by the use of the language, I'm going to say this is code from, some of this goes back to 1948, so I just want to
Oh my
be
gosh,
clear. So that's why we're using language like phonographs.
Right,
Exactly.
yeah, yeah.
And when you say loudspeaker, which is F,
Mm-hmm.
a Bluetooth speaker seems as though it would fit into, in fact, even I think the speaker on my phone, it's certainly not a phonograph.
Mm-hmm.
And so this would count as a loudspeaker. And so I think that's
Mm-hmm.
the clarification Councilmember Burns is looking for, to make sure that when we describe loudspeakers, we're not
Mm-hmm.
excluding regular devices that are used today, such as Bluetooth speakers or other portable speakers.
It's not even that. I think a better way to do this is to define what decibel level are we going to regulate? That's what I'm trying to first determine. Over what amount
It's just unacceptable in the city
right
without a permit.
triggers a need for a permit. Under what decibel, at what decibel level or what distance to residential does it require you to use a permit? Because whether it's a patio or whether it's your backyard, we still need to establish if it's within a certain distance to a residential or of a certain decibel level or a combination of the two, it triggers the need to get a permit. And that's what's not clear in all these changes. What will, leaving the loudspeaker versus the phonograph aside, will 75 decibel levels, and even the scenario that we walked through, will that require any type of permit?
Well, given the setting, which is a patio that's got members, groups of people coming together specifically to eat and drink and listen to music, and that's such a different thing than entertaining your friends in your backyard. And I don't know how we word that, the second group, so that it's different from the loudspeaker group.
Yeah, because so I guess what I'm saying is, in our council codes, we can work on this together, but I think it's, because the device itself really shouldn't even matter. It's the decibel level that should be regulated,
Well,
and
to-
not the device itself.
To that point, though, what it sounds like you're angling toward is regulation of the devices, because certain devices can generate certain decibel levels that others cannot. And so, the example I'm thinking of in my head is if you wanted to have like a DJ in your backyard, that's a loudspeaker. Even though you are not at a venue, it's still a loudspeaker that would not be issued a permit because you're within 150 feet of a residence because you have neighbors. But if you had a Bluetooth speaker, it's probably going to generate much less sound than the speakers that a DJ would bring. So,
But if you don't have a DJ, and sorry to interrupt, I just want to have a more fluid discussion. So if you don't have a DJ and you hook this up to speakers, that can achieve that a volume over a certain amount, which is what I'm getting at. Like,
Those-
what is that amount?
Those same kind of speakers
Yeah.
that a DJ would use is what I'm saying. Like, it sounds like you want to regulate the actual device and what's possible of what can be amplified by that device, because certain speakers might not even get to 75 decibels while others can do so easily.
Yeah, and that's why I think we should stay close to the decibel level. So it's like no matter where you are, I mean, you know, if we're the scenario that we walked through at what was the place again, Councilman
Canal
Burrell?
Shores.
Canal Shores was pretty far away from residential, and so we could say in that situation, okay, even though you're a certain distance away from, you know, if you're a certain distance away from residential, whatever that is, you know, it's 75 dBs from the property line. I'm saying, is that the same in residential areas?
Under
That
the
it's
current-
75 dBs, and if it's 75 dBs, does it not require any type of permit in a residential setting?
Under the current draft that's in the packet, you would not be able to get a permit in a residential area. So it's a non-starter. So to your point, the measurement doesn't matter, whether it's 75 dBs, 55 dBs, 20 dBs, because you're in a residential area, you would not be able to get a permit, period, for a loudspeaker.
Councilmember Burns, can.
Yeah, go ahead.
Yeah, thank you. And
Well-
if I can jump in really quick, I haven't spoken on this issue yet, and then I'll go to Councilmember Hedy Cadiz. I support the goals of this, and I appreciate when this was first discussed, I was among the folks who really wanted a hard, decibel line, and I appreciate that, and I'm sticking by it. I think that's a good way to do this and apply it equally. I do wonder if, 75 dB at a property line, if just, I'll ask Council Cummings this. If I'm at a park, or Councilmember Revelle, whoever wants to answer, if I'm at a park and I have my Bluetooth speaker and I'm playing it, let's say it's at 60 decibels, is that okay, or is that against the law under this proposed revision?
Under the proposed revision, if the park you're in is within 150 feet of a residence, you would not be issued a permit.
And so I couldn't play my speaker at all, at any level.
For that speaker, for that loud, quote unquote, loudspeaker. And that is one of the flaws of the code in general, is there's no definition of what loudspeaker,
Yeah.
phonograph, all of these
Yeah,
things that
yeah.
are they're not defined. So you would not be issued a permit for that loudspeaker. Whether you could actually use it or not is an open-ended question at 60 decibels, because that's not contemplated in the code at all.
But if I'm not issued a permit to use that loudspeaker, or whatever we're going to call it, the speaker, then I am, by definition, not allowed to do that activity.
You would be in
correct?
violation once you went over 70 decibels, 75, whatever the decibel level is. So in theory, if you're at 60 decibels and you don't have a permit, you should not be in violation of the code, because the only way we would be able to enforce the code is if you were greater than 70 decibels and within 150 feet of residence.
Okay, and then, okay, well, thank you for that.
I mean, I know I said that probably sounds confusing, but the way that it's drafted is if you're in a park and that park is within 150 feet of residence, the only way we'd be able to come and enforce that is if you go over 75 decibels, the way that it's currently drafted.
And I guess my thought is that we would try to address the scenario you just mentioned in a completely rewritten Section G that would talk about these more informal, smaller, picnic gathering or whatever, and not and no permit, but some kind, probably set a new decibel level limit for that kind of a setting, because I have heard complaints from residents who live across the street from lakefront parks, and particularly 4th of July, people come and set up all day very loud music, and it's, I'm sure, well over 75 dBs.
Yeah. Thank you. And then I have one last comment, then we'll go to Councilmember Hidekaris. I am, don't need to say this, the council member of the 8th Ward. I share the border with Howard, and along Howard Street, I have a lot of, more and more, the business district is becoming more and more vibrant. I live on Callan near Howard. And just the other day, Packaged Pig, great neighbors in the city, had an event, and they had a jazz band playing. And from my apartment, with my window open, I could hear the jazz band. I was delighted to hear it. It did not bother me one bit. But they are right across the alley from an apartment building. They're certainly within 150 feet of a residential area. And the jazz band was louder than 75 dB. So would that be allowed?
So was the band amplified by a speaker? Or were they just outside playing?
Certainly, it sounded like parts of it were. Certain instruments may have been amplified.
And were they indoor or outdoors?
They were outdoors.
So as long as they were not outside of the time restrictions, which are in F3,
If they were more than 75 dBs, they should probably have gotten a permit.
yeah, that too.
They would have, okay.
I mean, using the speaker, they
Well,
should have
more
gotten
than 75. But they can't go over 75.
using
So they would have been limited to 75 dB. So if they had an instrument that was going over 75 dB,
the use of a speaker requires that they even get the permit. Let's just start there. Like if that's why I asked, the first question I asked is whether it was amplified by some sort of speaker. Because the code, either currently or as proposed amended, doesn't account for playing live music without amplification.
okay. And then okay, that gets to my second point. The next day, right across the street at Palm House, same owners, another great asset to the city, there was I don't know what kind of gathering it was, but there were a lot of folks of Latino and Latino descent, and they had a mariachi band. And it wasn't amplified, but it was a trumpet and guitars, and it's, again, beautiful music. I enjoyed hearing it, but fairly loud. And so we're saying that someone with a speaker can't play at 75 dB, but if I go out with my trumpet or my guitar and I'm strumming aggressively and I'm hitting 85 dB, 100 dB, I'm fine to make that noise?
I would think not. I mean, if you look at some of the ordinances from some of the other communities that I sent around, I mean, no way would that be allowed after 7 p.m.
Mm-hmm.
But I think Evanston's a very different community from most of our northern neighbors who don't have these entertainment opportunities. Was the Palm House, was that indoor music, or?
Well, I would say that based on, F, it doesn't really matter if it's indoors or outdoors. It's about how much noise is emanating from the property line.
Right, yeah. But we're getting into, what?
Actually, I take that back. F1 does contemplate musical instruments.
Yeah, so even if it was the music, F1.
And G does as well. I mean, that's what G does as well.
And so that leads me to, and so I asked those questions. Thank you, Council Cummings, and thank you, everyone. So it does include musical instruments. It does include things that aren't amplified themselves. So with that, I think this really begs back to what Councilmember Burns was saying, that I think we just need to set a decibel level that it's unacceptable to make noise above this level. If you're doing that, whether it's with a speaker or with a guitar or a trumpet, whatever it is, you just can't do that. So I'll just throw my hat there. And then Councilmember Hidekaris, and then I think we're close to moving this on.
So one thing we could do, so there was talk of the outdated terms.
Mm-hmm.
We could change loudspeakers to PA system, because typically when you have a concert, you have a PA system, and you could change the Article G to, personal speakers and home stereos. You could also add, to the ordinance, instead, you could say PA system, commercial stereo, and that would eliminate, your Bluetooth speaker or your, stereo setup in your house. That might be a way to kind of clean that up as well.
Thank you. And I'll just, for the committee, the definition, general definition of a PA system is obviously a public address system, which means that it comprises of both microphones, amplifiers, or, loudspeakers and related equipment. So I think it would require some mix of those, of at least a microphone and something that's projecting, which would be different than just a speaker that doesn't include the microphone. But if that's what we're trying to regulate, that's happy to do that. Okay, so are there any amendments at this point? Are we gonna, or?
I'd hate to amend it on the fly without.
So I think we're gonna send this, so I think I'd entertain a motion to move this forward to council with discussions between members and Council Cummings to incorporate a few changes before it gets to council.
Right.
Is there a motion on that?
Yeah, I so move. Thank you.
Moved by Councilmember Revelle, seconded by Councilmember Burns. Is that motion clear for, I think it is, so folks will work with the law department to make adjustments, and those will be incorporated for council.
So I just want to get clarity, because we will certainly work with the committee and members we have been trying to make sure we get this right. The motion before the body is to essentially approve the ordinance as is to advance to council. My understanding is that the council agenda it will appear on is the 27th, and between now and the 27th, the law department will have feedback from the committee.
For members of the committee, yes, and
Right,
those
yeah.
changes will be incorporated into what is
Presented to
presented to council.
Yeah, and in particular, we'll be adding amendments to subsection G, I think is where a lot of this fine tuning will come.
Yeah. Okay, it's been moved and seconded. All those in favor say aye.
Aye.
All those opposed, any abstentions? I also support it. That brings us to our next item of business. And I just do want to take a quick moment as I'm introducing these items, a quick moment of personal privilege. Because it was raised at public comment, it's been there's been a lot of internet attention about this. So I just want to say that there is an article that appeared in Evanston Now that grossly distorts my position on the ordinances that are to follow. I give Evanston Now the same attention I give Fox News. I engage only to glean from it a kernel of insight into the other side's perspective. And it feels unfortunate that I even have to say this, but I am not pushing for topless beaches. I've never said it. I've never thought it. It does not appear in any memo. Bill Smith, the editor and writer for Evanston Now, completely made it up. The package of ordinances that I put forward address issues of equal rights, civil liberties, and constitutionality of city ordinances. For example, the ordinance relating to the specific regulation of female breast in public, Article 1, Section 18 of the Illinois Constitution states that no discrimination on the basis of sex is allowed in Illinois. The equal protection, and this is quote, the equal protection of the law should not be denied or abridged on account of sex by the state or its units of local government and school districts. And we'll get into the particulars of each of the ordinances as we go along. But again, these are the proposals are based in law and interpretation of statute. And, we'll discuss them, and I'll say this, none of the proposals individually are groundbreaking or going to have a huge impact on the day-to-day lives of most residents, but collectively the packages of code revisions that I'm putting forward will decrease opportunities for negative interactions with law enforcement that sow distrust with marginalized communities. And, I just want us to really think about these critically. The rhetoric that was put out by Evanston Now and Bill Smith is dangerous. I have felt slightly unsafe in the last few days because of that article, because I've received emails from folks and messages online from folks that aren't from Evanston that have, thin blue line profile pictures and are emailing me about critical race theory and equity, and it's somewhat intimidating, and it's a complete distortion of what's going on here. And so I'm looking forward to a robust debate about these items and hearing everyone's opinions on them. And so with that, we will move forward. And that brings us to HS3, Ordinance 19022, amending portions of the City Code 9520. I'm reading the completely wrong thing. That brings us to HS4, Ordinance 56022, removing Title 9, Chapter 5, Section 18.1, obedience to police in a public place. Chairs, I guess, can move things in committee, so I move that. Is there a second? Seconded by Councilmember Hadikotis. Okay, so that brings us to that item. I will open up or first I'll allow any light, so if anyone wants to make a comment on this. Councilmember Braithwaite.
This is a comment on this as well as how you teed it up. And so I could make the same comment to many of these, and I would like to utilize my time to respond to you and to this list that was in front of us. My response is, Councilmember Reed, that you somehow branded yourself. I don't think you or any other member of council should ever feel threatened by thoughts, opinions, legislation that's put forward. But my however is, and I've said this before, I think based on experience and years in council, what good legislation, what best looks like, is one that's collaborative not only with our staff and our public. I do agree strongly with Betty Sue Esther, which I say this with a smile. She asked where was the community engagement. And I don't have any reference points for any of this, which then allows for the reporting to report without any context from your residents. I think that there should have been collaboration with the law department. I definitely think there should be a collaboration with the police department. And with the absence of the community engagement piece, you leave yourself open to this time and time again. I don't know where this conversation is going to go tonight with my other members, and I haven't had time to have that conversation based on dealing with personal matters. But I am concerned with the direction of some of these suggestions, and I think as a parent, someone who raises young people, and for anyone else on this dais that has kids, for me to read this, it is, I can't even find the word to characterize it. It is probably best that I don't. But what I will say is, I, like many other people here in the city of Evanston, it's a conscious decision. You choose to live here, and a lot of it has to deal with the family values. And I just don't know where your reference point is for many of these, particularly for our children of color, when I have to read this. And finally, I'll use the example of alternatives to arrest with Chief Eddington. I have a great deal of respect for your approach in collaborating. You sat in on those, Councilmember Burns, and I don't know where he is. I'm gonna call his name, because he actually came to those meetings where it took us 2 years to make changes to get the alternatives to arrest, which I think has had a huge impact and will continue to do so. And why? We talked to our law department. We spoke extensively to our police department. We even had our police detective bureaus there. We involved members from Northwestern University, Alderman Revelle, Fleming, a very diverse group of people, and we literally met for 2 years before we made the changes. And here you are, we were just looking at one specific target group. I mean, there's 1, 2, 3, 4, 5, 6, here, and this is absorbing staff time for what you have our public at face value laughing and not taking this seriously. So I guess if my advice is, if your intent is truly to impact change, moving forward, I would suggest public meetings just to see what your residents think and feel, and then also getting feedback from our staff, our law department, our chief of police, and at the very least, before they appear on a council agenda, you might want to socialize it a little bit with our council. But a list of these I'm not going to support, and since you've given me the time to make my comments, I'll just vote no on at the appropriate time, and will not second many of these. If there isn't a second, then that should be consensus to say that there's no one that's in support of them. Thank you for my time.
Thank you. To this ordinance that is up on the agenda, or up on the docket now, which is obedience to police in public places. So first, I actually want to address some of the things you raised. So there have been public meetings that were scheduled previous to this meeting, which this is a part of the public discussion process. Folks are able to give public comment. This is a part of the normal legislative process. But beyond this, these items have been previously discussed and sent out on a public agenda. In fact, this went out on a public agenda for the Mayor Biss's committee. The name of it is slipping my mind, the Reimagining Public Safety Committee. So this went out on a public agenda for the Reimagining Public Safety Committee. I have worked with staff, with Allison Lepsinger, who is the policy coordinator, who I've had conversations with, not Nick on these items, but with the law department, with Alex Ruggie in the law department. As far as staff time, I myself drafted the actual language for the ordinances. I worked with Allison to even draft the whereas statement. So this was pretty a minimal invasion on staff time, as I did most of the heavy lifting to actually draft each and every one of these, including even writing at least one of the memos on this. And so, it wasn't a huge burden on staff time. And I also want to say thank you, Councilmember Braithwaite, because the foundation that you laid and that other members of the council laid with that Alternatives to Arrest committee work, it made moving these forward easier. It answered some of the questions that would make doing this work easier. That's the point of continuous bodies. We learn from past efforts, and it makes future efforts easier. So thank you for taking that heavy lift early on a few years ago. To this particular ordinance, it's obedience to police in public place. It says, any person in or on any public place in the city who is violating any provision of this code or any statute of the state shall immediately cease such violation upon the request of a police officer. That's almost, and correct me, Nick, if this is wrong, it's almost like a preamble to this, because then the next sentence says, it shall be unlawful for any person to refuse to obey the command or direction of a police officer. So, just Council Cummings, based on your reading of that, it's, can you maybe just, does the first sentence, it seems to me that it shall be unlawful for any person to refuse to obey the command or direction of a police officer. That's what is said to be unlawful. Is that correct?
The behavior that is unlawful, according to the code that you cited, is refusing to obey the command or direction of the police officer. That's correct.
So, but just the command, any command, it seems, because that's what it says is unlawful. So they can command you to do anything, and if you disobey that, that's what's unlawful, based on the plain language of this ordinance.
Well, you have to take the entire ordinance together, not just the single sentence. You'd have to also include any person in or a public place who is violating any provision of this code as well. It can't be the individual sentences in a vacuum. They're there together. From the legislative intent of this council is for them to be read together. So it would be unlawful to disobey a police order to essentially stop violating the city code.
Or a state law, only in a
Or
public place, but
state
if you're
law.
doing it on private property, it's just fine?
If you're breaking the law within your own home, and the police have no probable cause in which to enter
They
your
have
home,
problem. They're in your house for something, for a probable reason. They're lawfully there. They see you breaking the law. They tell you to stop in your house. This law wouldn't apply to you, correct?
the way that it's drafted, no.
Okay. And then I will say, Section 11203 of the Illinois compiled statute says obedience to police officers. No person shall willfully fail or refuse to comply with any lawful order. Keyword, it says any lawful order or direction of any police officer, fireman, person authorized by local authority to direct traffic, school crossing guard, and all these other things. So the state law on this very same topic, and sorry to spring this, Nick, it's 65 ILCS 5-11-203. The state law.
Could you give me that citation again?
Yeah.
Because it's 65 ILCS.
65 ILCS 5/11-203.
That seems weird because that's not the criminal code, but that's the municipal code. So
That's, I think, the vehicle code.
that's 625 ILCS.
Yeah,
Vehicle
did I
code.
say 725?
You said 65.
Oh, that's like dyslexia or something. 625 is what I meant to say.
625 ILCS
5/11-203.
Okay, yes, that is definitely the Illinois Vehicle Code.
And it says obedience to police officers, but it doesn't, it says obedience to police officers. And it says no person shall willfully fail to refuse or comply with any lawful order or direction of any police officer, fireman, and so forth. And again, the key word there is lawful order, whereas our ordinance does not say any lawful order. It just says any order. And I think that the state statute is sufficient to cover a lawful order. Unless Council Cummings, you have something, I'll go to Councilmember Braithwaite, who's turned on his light.
No, I'm actually trying to find the criminal code, and I don't know if Chief Eddington can help, but I believe there is a misdemeanor under state law for failure to obey a police officer's direction under the criminal code, not just the vehicle code. And I'm actually trying to find it.
Okay. And since Councilmember Burns has not yet spoken, I will go to Councilmember Burns.
And I just want to help narrow us in. I think on one of the cases that has prompted this, I think it was Lawrence Crosby, I have that name
Yes.
correct, who was, I believe, arrested and charged for this.
Yes.
And it was determined that he could not have, if the ordinance was written, and I think the manner Councilmember Reed is suggesting, any lawful order. I think what we're trying to determine, Council Cummings, you might be to help with that, is how does someone who on the scene, it is determined that they did not, and maybe this wasn't the case, but on the scene, if that person was determined that they did not disobey, that they did violate any, local or state statute, criminal, code, local criminal code or criminal state statute, how are they then still charged with disobeying in order?
So there's two things I want to point out. Eliminating this portion of the code eliminates the police's ability to give an ordinance violation as opposed to charging the misdemeanor, and it's under 720 ILCS 5/31-1, resisting and obstructing a police officer. So instead of being able to write an ordinance ticket for failure to obey, you now have a potential resisting and obstructing charge, which is something that we probably don't want to do. Secondly, the determination of whether someone is violating a state or local law is left up to the discretion of those who are the law enforcement agents on the scene. And if it's later determined that they were not violating the state or local law by some other authority, whether it be a judge or administrative hearing officer, then they would not be liable for that ticket that was issued under the ordinance.
If I can point of order on that, because you're saying that, so someone cannot be, are you saying that someone cannot be arrested for this law?
I mean, the Illinois law allows police to arrest even for city ordinances, right? But my point is that they have the opportunity under a city ordinance to write an ordinance ticket where it goes to administrative hearings and they pay a fine, as opposed to being arrested, charged, and prosecuted by the state's attorney.
Can you be arrested for a petty offense? You can be arrested even
You can
for
be arrested for any ordinance violation.
any ordinance violation.
Or state law violation. The
I wanna
Illinois
make
law
that
allows
clear.
that to happen. They can. It just doesn't, they don't have to. They can be arrested.
And then I'm going to let
Or that.
Interim Manager Ganderski speak, but I want to make one quick point before you do.
I wasn't done yet. so-
Yeah, no, and I'm going to go back to you. But specifically under this, specifically under this, Lawrence Crosby, who was charged only with this, did not receive a city ordinance ticket. And please, someone correct me if I'm wrong. He was sent to Skokie Courthouse to deal with.
So that sounds like resisting or obstructing, which is a state law.
He was charged
law
with
violation.
obedience to police in a public place.
He likely was also charged with resisting or obstructing in order for him to go to Skokie.
So if somebody's charged with multiple charges, then it automatically goes to Skokie.
So in my experience as both an assistant state's attorney and now as the corporation counsel for the city, if someone is arrested and there are multiple charges, whether they be state charges and or local charges, all of them go to the state's attorney.
And so this law almost necessitates that because you're already breaking the law, that there would be multiple charges.
Not necessarily. It's up to the police can exercise discretion. It can certainly escalate, but
Let me go to.
Good evening, Chair Reed and members of the Human Services Committee, Interim City Manager Ganderski. I have extensive experience with administrative hearings, which is why I wanted to step in. So when municipalities create ordinances that are, for lack of a better term, I'll call them quasi-criminal, or they fall under the health, safety, public safety sections of municipal codes, they do that to provide this alternative to arrest, typically. So you can issue, under the code section as it exists now, one could be issued an ordinance ticket where they would just go to administrative hearings in a non-criminal setting, maybe receive a fine. If you, and I'm just bringing this up, it's up to the committee obviously to do what it wants to do. If that's repealed, then the only alternative in a situation of like manner would be to refer to the state criminal code. And that now we're talking about an arrest where someone is going to the Skokie courthouse. So it actually eliminates a possibility for someone to receive a minor ticket as opposed to having to go under a misdemeanor ordinance violation. And Nick is correct that when you are arrested, you can be arrested under an ordinance violation as well. But typically what you see with those are state charges with an ordinance violation. And 9.5 or 9.9 times out of 10, the ordinance violation is dropped by the state's attorney. So it's usually they're arrested for a more considerable offense.
Council Member Burns.
I think what this gets at is what I'm uncomfortable with is you're being investigated for something, and in the moment, not later on, it's found that you did not do the thing that they were investigating you for, and yet and still you're arrested for it. And even though your protest, in a sense, was determined right then and there that it was what's the word I'm looking for?
Lawful. You were.
I can't say lawful because they're
Justified.
saying it was justified. Thank you. I can't say lawful because what they're saying is just the mere,
Disobedience.
justified protest of that interaction that you know is wrong. Because in the case of Lawrence Crosby, I mean, this is my vehicle. Even that resistance is unlawful.
so that resistance
Which would tell me that we want people during that interaction, whether you have a justified reason to protest or not, you are supposed to stay quiet, and whatever the officers tell you to do, you do in that moment, is what we're saying. And if that's what we're saying, that is what it is. But that's what I'm trying to get at. I'm not sure where Councilmember Reed is, but Lawrence Crosby, I think, is a really good example of something that was settled there in the moment. I think they verified in the moment it was his vehicle, and yet and still he was still taken away from that place.
That's not
And charged with something. A local charged with the local code, as well as you're saying possibly the state code as well, which I'd
most
like to,
likely, yes.
Okay, I'd like to see if that was the case. But we definitely had the ability to not charge them for the local code. So that's what I'm trying to understand, is how does that all work?
So to go back to one of your original points, in every talk that I've ever given to young people with respect to their interactions with police, particularly young black individuals, the advice that's given to them and some of my colleagues that have served as judges is to you settle that dispute in a courthouse. You don't just settle that dispute in the street, because you will lose that dispute in the street. It's not appropriate for you to challenge right then and there on the street. And so, yes, the Illinois state law makes it a misdemeanor to resist and obstruct an officer trying to do their job. In the instance that the example you're given is conduct an investigation. I believe the city paid out money to Mr. Crosby as a result of that interaction.
$1.3 million.
So, that was prior to my joining the city. I have a very cursory knowledge of the case. I don't know the exact charges that were brought, but I can tell you that from my experience as a state's attorney, unless the city of Evanston is prosecuting ordinance tickets in Skokie, and as the Corporation and Council, I can tell you we're not, unless they're traffic tickets. He likely was charged with something else that would have taken him to the state's attorney. And that is unlawful, to obstruct or resist an officer trying to conduct their duties. To answer Councilmember Reed's earlier question, our police officers still maintain some discretion. If you are observed to be potentially breaking some law or ordinance and you're told to stop and you stop, the officer is not required to arrest you because you were previously breaking the law and then stopped. But if you fail to stop, this ordinance allows that officer to write you an ordinance ticket and pay a fine, as opposed to arrest you on the scene, book you into holding, and appear in bond court in front of a judge. That's all.
If I can just point of order, and then we're going to go to Councilmember Revelle, which is that Lawrence Crosby is an example. I was an example. You weren't here, neither was Kelly, but while I was running for city clerk, engaging in nothing other than petitioning to get on the ballot for city clerk 4 years ago, I was arrested here in Evanston and charged with obedience to police in a public place, and that was my sole charge. And I was going to have to go to Skokie Courthouse to adjudicate this. It was not a municipal violation. I wasn't going to come here to administrative adjudication. I was literally arrested and removed from the street and removed from my ability to petition the day before the filing deadline. And I didn't have to go to Skokie Courthouse because the charges were dropped internally after I raised it. I don't know if that's even allowed or if that should have happened, but it happened. And I was not an official at the time. And so I want to note that, that may be a new practice, but that was not always the practice, and we have arrested people. And I get what you're saying about young men of color and telling them not to adjudicate it on the streets and they have to win it at a courtroom, but what I am trying to do is lessen the number of interactions where young people in our community are going through this. I went through it, Lawrence Crosby went through it, the city lost millions of dollars and maybe elected a clerk that a lot of people didn't want because of this. So we want to make sure that we're cleaning up these laws. And I want to add one statistic, because I FOIA'd this data a while ago, that as of this was in 2017, so at 6 years going back to 2011, so from 2011 to 2017, there were 50 people arrested in Evanston who were solely charged. Their only charge was this 9518 obedience to police in a public place. 50 people arrested in that time, and that was their only charge. I was one of those 50 people. Lawrence Crosby was one of those 50 people. 36 of those people were African American. 6 of them were Hispanic. 8 were white. This law presents a clear outcome that is disproportionately impacting folks of color, particularly young folks. Councilmember Revelle.
Early on, many minutes ago, you mentioned that you had brought this idea, this particular issue to the Reimagining Public Safety folks, and I was just wondering what the reaction was, and did they want to take this up?
It appeared on I want to be specific in my language. I said it appeared on a public agenda. The committee reviewed it. We did not make quorum that meeting, but folks were able to provide feedback, and there was no opposition raised.
Okay, but they didn't say, well, we're going to add this to our list of recommendations or anything like that?
Well, the committee it wasn't working on that, and that wasn't the goal of taking it to the committee. It was more so just to get some eyes on it and have folks be able to weigh in if there are any, things that they really that they felt were pressing.
Okay, and so the data that you've just given us goes back to 2017. I'm wondering if Chief Eddington would like to comment on more recent experience with our police department and what kind of record we have.
Thank you, Alderman. I appreciate it, Mr. Chairman. I want to revisit something that I think is critically important. If our goal is really to minimize negative interactions, then I would strongly suggest that the ordinance be modified to match state law where we add lawful order, but to create a situation where we know if we have to take this action, the individual is going to be booked for a misdemeanor. Now we're talking fingerprints, now we're talking a mugshot. Most background checks will pick that up. If it's a local ordinance, you are going to have to contact the specific municipality. And I think that's an additional protection that the way we're doing it now affords individuals that find themselves in a difficult situation with law enforcement. And I think as we look back at these events, and frankly, I was kind of taken by surprise of the number of ordinances were on this agenda. I think last time when we had, I thought, a robust discussion of burglary tools, I was able to bring information back to show how this worked and to understand the concerns of the council members about the burden we were putting on an individual to prove their innocence on the street. And I think that you have a recommendation from the law department that addresses that. So when we have the time to research and look at these things, we have the time to research and see what the outcomes were, I think we come to more informed decisions. But I think the one thing they can speak to specifically tonight is just with the numbers that Chairman Reed just cited, do we really want to funnel those 50 individuals into the Cook County criminal justice system? I think our collective answer is no. And I think we have the tools to work with that here. To anticipate that policing in a free and democratic society will be mistake-free is not going to happen. It's how we clean up the aftermath of those impacts. And so I would strongly suggest that we look at this. If we tweak the language, please allow the police officers to have the discretion to say, where should this person go? And I think another one we're going to come up to tonight is rock throwing. I think one of the public comments already mentioned this. If you're throwing rocks at a CTA
If we can
train,
take every item one at a time. Apologies, yeah, if we can.
Yeah, you just give us the option. Give us the option. Thank you.
Thank you. Council Member Braithwaite.
Thank you, Chief, for your insight. And I would just share this to, I guess Harry Cars would be the only new, and Burns only new committee member. What I heard earlier from you, Councilmember Reed, were individual examples that have a huge impact, particularly on an impact that it took us 2 years to accomplish with alternatives to arrest. I want to thank the city manager, Kelly Gandersky, and Chief for sharing, and as well as the legal department for weighing in. Here's what I hear, and that is these changes, not only were they not supported by residents, just based on the feedback on Evanston Now, I also hear that they're not supported by our staff. And so I don't want to regurgitate what I said earlier, but I'll close with this. If I don't like the taste of the water, I'm not going to call Dave to tell him to tweak the formula. if I don't like the fire department's response, I'm not going to try to micromanage the chief and tell him to go to this ward first. And we don't have the ability to tell HR who to hire and who to fire, with the exception of the city manager. So I want to strongly urge that if you are, if these are things that matter to you and the people that you serve, that you host the public meetings. And I definitely think, me for one, it's really difficult to sit and watch like the constant grilling of our staff with a barrage of questions that you haven't given the courtesy to answer. And I'm really impressed with you, Nick, by your composure, I have to say it publicly, to be able to answer and respond to these questions without losing, who you are. I've heard that comment from many people, so I think it's important that I say it publicly, because I appreciate who you are, how you represent not only yourself, but also how you represent the taxpayers and our corporation council. These are important to you. Take the time to talk to our staff and then bring them back. But the back and forth barraging of our staff, I'm impressed with your ability to read and your insight, but at the end of the day, I'm going to trust our staff and what they're saying, because they get paid and they've been educated to protect our corporation council. I do regret, to the members of the committee, I still have family in town based on personal reasons. I'll just state that I'm not really in support of many of these things, and then we'll look forward to revisiting them if they come back with a staff recommendation. Thank you.
Councilmember Burns, but I just want to point, what I feel like I just heard you say is that we are not here to legislate. If I disagree with something, that a law that is on the books, I and the other 10 council members are the only folks who have the authority to vote on and change those laws. So if we weren't put here to change laws, then I don't know what the heck we're doing here. Councilmember Burns.
Read the public comments in Evanston now. And
The
respond
public
to them.
comments on Evanston Now are ill-informed folks, and some of them are racist, clearly. And if that's the way you're legislating by Evanston Now, God help us. Councilmember Burns.
It's, I guess, just for, I don't know where this is going to go today, but I just for myself need to know moving forward, is there anybody that has been arrested merely for disobeying whatever the I can't remember exactly what it's called, but the local
Obedience to
code,
police in
obedience to
public place.
police in a public place.
Yes.
That was arrested and they weren't charged also for violating state statute. And I don't need an answer now to Councilmember Braithwaite's part. I'm not trying to, but I need an answer for that, because that's where I'm coming from. So that's one. And then,
If I can answer that, the statistic I gave is yes, between 2011 and 2017, the last time I got data on this, 50 people were arrested solely for the Evanston ordinance charge. I sent it to everybody by email during the meeting. You can review the FOIA.
And Council Cummings, would you concur with that, or you're saying that shouldn't be the case, that they should be given a ticket and that's all?
It's not appropriate for me to opine on how Evanston police should actually police the community, to be fair. I can just say that in my experience as a former assistant state's attorney, that if an ordinance violation came into my courtroom, it usually was accompanied with a long form complaint for a state statute violation in addition to the ordinance violation. It was the case that I got straight up, unless it was a Cook County Sheriff's Police for, having liquor in the park or something like that. It was rare as the case that I had a municipality, and at that time I was prosecuting the southern suburbs. It was rare that any of those communities would come in with simply an ordinance violation and nothing else attached to it. 99% of the time it was attached with a state law claim. Now, insofar as how Evanston operates, I'm happy to work with Chief Eddington and the leadership in the Evanston Police Department and the city manager's office to ensure that, we are practicing things that don't lead us to arresting people for ordinance violations only, because I think, when the idea of the ordinance violation is meant to try and be less punitive than an arrest situation.
Yeah, and I just want to be clear that I'm more so asking what, our police officers are allowed to do and not allowed to do per our city code?
So under the law generally, and I had to use this lots of times as a state's attorney defending the sheriff, ordinance violations can be enough for an arrest.
Okay.
Interim Manager Kelly, or I'm sorry, Ganderski.
And I'm not done yet, but
I know.
But yeah,
I
I
can
want to
offer
hear.
a little bit of insight, and here's why. My last legal position I held at the City of Chicago was the supervisor of the misdemeanor branch courts. So the reason why the City of Chicago shows up to the state's attorney calls for the misdemeanor claims is to prosecute the ordinance violations. It was extremely rare, and I will say I can't even remember on one hand if we ever alone had an arrest just for an ordinance violation. It was almost always accompanied with a state charge. And if the city attorney was not there to prosecute the state charge, or the municipal charge, it was usually dropped unless the state's attorney would agree to bring it forward for us. But typically the judges had very little patience for municipal charges only. So ordinance charges only don't really fly in the criminal realm, because Council Cummings is correct. It's meant to be less punitive, and if you're just going to issue some sort of violation for a municipal ordinance, it really should go to administrative hearings unless there's an underlying reason for the arrest. Meaning, and circumstances vary, and that's the discretion of the officer. But typically, if someone's getting arrested, they're going to get arrested with a state charge.
In the specific example that I'm thinking of, there's a case law out of the city of Chicago where the person was accused of burglary or robbery or something of that nature, and the police had stopped him for an ordinance violation of riding his bicycle on the sidewalk. And the question was whether that was enough to establish probable cause was the ordinance violation, and the court said it was. Right, so it's enough to even approach him and probable cause to arrest him while they investigate that he was the suspect in the burglary. But the Seventh Circuit has said that that's enough for an ordinance violation for arrest.
Textual context to conduct a search.
Probable cause for arrest, period, is an ordinance violation.
Yeah, and I guess what I'm still trying to sort out is I think if someone in the moment is in the Lawrence Crowley situation, puts his hands up, people are telling him to get down, and he's like, let's say in a similar situation, they're like, well, this is my car, but they're like, get down. He's like, but this is my vehicle. I can show you. Is that enough to say he's disobeying an order? And would that lead to not just a ticket, but an arrest, especially if it's determined on scene that it was, in fact, his vehicle? And, disobeying to me, is a broad enough term to where it doesn't need to mean that he was like physically trying to get away from being, arrested, but more so even just okay, get down. And as they're approaching, he's like, but this is my vehicle. Like, I can show you right now. And it's one thing if that leads to a ticket and maybe something else, but to lead to arrest, I think, is what I'm trying to establish if that happens. And it sounds like it can. And I think in between this meeting and wherever this goes, I just want to know, are those type of situations leading to arrests as opposed to just tickets?
And the point I wish to make, regardless of this ordinance, your fact pattern, and I'm not here to second guess what happened in 2017 or 18, regardless of this ordinance, that's sufficient under Illinois law for resisting and obstructing. So that could be an arrest for a misdemeanor as well. So regardless of this ordinance, they could still be arrested for resisting and obstructing. And my understanding, even of the fact pattern with Councilmember Reed, there could be obstructing identification is also another, like refusal to give over your ID.
There's no law on that, just to be clear.
Okay.
There's a law that mandates that on the street you have to produce ID for police officers in Illinois?
720 ILCS 5/31-4.5, obstructing identification.
Can you read that?
Obstructing identification is when he or she intentionally or knowingly furnishes a false or fictitious name.
False or fictitious is the key word there. False or
residence,
fictitious.
address, or date of birth to a police officer who has lawfully arrested or detained or requested information from a person that a police officer has good cause to believe is a witness to a criminal offense.
Yeah, and so refusing to give your ID is not a criminal offense in Illinois unless you provide false or fictitious information. I'm very aware of this. I was aware of that before I was arrested for it, and that's why I knew I had the right to uphold and not provide an ID, because it says false or fictitious. Councilmember, I'm sorry, were you?
One more thing, and what happens after, if someone's given a ticket, then what happens? Is that like a fine they have to pay? That's what it is? Okay.
Yeah, they would go to administrative hearings, and the administrative hearing officer would either assess a fine or not.
How much can what's the maximum or minimum for the
The
fine?
maximum fine that the city of Evanston is allowed to levy in any ordinance violation is $750, with the exception of building code violations.
And so someone could be charged up to $750 for this?
Yes.
And I just want to note the state code says $150.
The state code is a misdemeanor altogether, so.
Well,
whatever the
I'm
penalty-
referring to obedience to police, specifically.
Opposition?
Yeah, specifically 65 or 625 ILCS. Obedience to police officers, no person shall willfully fail to refuse to comply
So
with the lawful order.
the vehicle code is something different. It could be a petty offense, and I don't know what those.
It is,
off
yeah,
the
a
top of
petty
my
offense.
heads. I don't know what the petty offense scale is.
It says 150 in this particular.
But again, it could be also charged as a Class A misdemeanor, which has other fines and fees associated with it.
Councilmember Burns.
Yeah, and I can put in an official request for this. I'm wondering if we've ever ticketed someone for this, and have they ever gone through the administrative adjudication process for this purpose?
So I'll note, Councilmember Harricars is next, but I'm willing to hold this or table this to the next meeting to get more data, because I think the data is only going to elucidate how important this is and really expose that what we're saying our goals are may not be exactly what's happening in reality. So I'm happy to hold this and to provide even more information to make the case on this, to make it crystal clear for folks, as long as we're able to get that data. Councilmember Harricars.
I was just going to bring that up. I don't have enough information to make a decision now. So I'd say that we should hold this. I think it would be great to look at all the cases that we have and see what exactly happened, and have a little bit more information. And possibly, I do agree, like, if you didn't do something wrong, you should not be arrested for it. And I don't know how to do that legally. I'm not a lawyer. I think we'd have to lean heavily on our legal team to figure that out. But I guess I'm making a motion to table.
Yeah. So with that, I'm happy to entertain a motion to table, but specifically with the guidelines that we received data on between 2015 and now, the last, whatever that is, 7 years or so, how many folks were arrested for this charge? And so I just want to, Chief, I think, do you have something? Yeah.
This is a police computer-related issue. If you could make your motion 2017, I'm confident the data from 2017 on, 2015 is going to be kind of squishy. And so I would respectfully request that you consider that amendment. Thank you.
I hear that. I'm happy to do that, but I will say that misses out on some key data, such as Lawrence Crosby and other cases that happened in 2015. And even, my arrest happened in 2016, and so it would exclude that. And I think knowing that this is an ordinance charge that has cost the city, its enforcement has led to the city having to pay out over $1 million and potentially putting the city at more liability with cases. My case could have been a lawsuit. There are other cases that likely could have been, cause the city legal liability. I think it's important to include those, but I'm happy to go back to 2017 and forward and understand how many folks were arrested, how many of those arrested folks were given a local ordinance sent here to administrative adjudication versus sent to the county. And I think something even just as important that we don't really keep data on because it's held by another unit of government, but we can get the data, is how many of these were just dismissed outright in court. If this is a law that we're charging people with and it's just going to court, as as Manager Ganderski, Interim Manager Ganderski said, it's tricky to get the data. Go ahead. Go ahead.
I'll tell you why, because a lot of times these get dismissed so that it's like a settlement, right? So we'll dismiss one charge and keep another, or they'll plea on another. So a dismissal may not mean that it wouldn't have gone forward. It just could mean that it was a settlement. So
Or
just
maybe
wanted
they-
to bring that caveat there.
Or there was some deferred prosecution
Yeah.
or some other reason why it was dismissed.
I think it still might be worthy data if we can get it, because it'll help us determine how is this being enforced. And I mean, particularly if it's with other charges, that stuff we can see. But I'd love to get from 2017 to now, how many folks were arrested with this? How many of those were adjudicated locally versus sent to Skokie Courthouse?
And how many arrested, just to reiterate that, because some,
Yeah,
just
how
to
many
make
are
sure-
arrested, and then how many are arrested solely with this charge?
That's what
and
I'm
nothing
mentioning.
else?
Yeah, it's, and then also just to better understand how much discretion an officer has around that the state, the resisting arrest. Because I heard you say they can, but they don't have to. And so if they don't have to, we could write it into our code that they shall, right, give a ticket in certain situations. So I just want to see how much discretion do they have, specifically with the resisting arrest.
Well, so that everyone understands, the criminal code is written to not necessarily dictate the behavior of the officer, but to dictate the behavior of the rest of us.
Right.
So there's nothing in the law that says that a police officer has to arrest someone for violation of this particular behavior or this offense. So that discretion is naturally built in because
Okay.
the law is written to regulate the behavior of the non-sworn personnel. Now, there are laws that regulate sworn personnel, but that's totally different. That's like official misconduct and stuff like that.
I think that's important for this discussion because we can build into our local code some clear direction as to when it should be escalated and when it shouldn't, because I think that's what we're trying to achieve here. And I think with this data, it'll allow us to know at what, where that line should be. And obviously would love to talk to Chief Eddington more about this to see if this is something where we can establish a very clear line so that we're not arresting people if we don't have to. And if this is a way, an alternative to arrest, that we're utilizing it, at every opportunity. And I think we have to fully define when those opportunities are for our officers so it's clear for them. And that's all, Chair. Thank you.
Thank you. So that has been moved and seconded. I think everyone is clear on the information that we are looking for. And we'll have that this will be moved on to our next meeting. So all those in favor of tabling this to the next meeting with the expectation that this data that was listed will be provided to the committee. All those in favor say aye. All those opposed? No? Oh, okay. And then any abstentions? The motion passes, and this will go to the next Human Services meeting with the data provided. I'd like to move HS 8, Ordinance 58022, making changes to Title IX, Chapter 5, Section 10, alcoholic beverages and cannabis, consumption, possession on public property. Is there a second?
Second.
Seconded by Councilmember Burns. This is another ordinance referral that I made here, and it is really meant to, again, just be a cleanup bill. I'm going to bring it up here. The key changes with this ordinance, and again, this was another one that was grossly misidentified by Evanston Now. So what this would do is it is illegal for anyone in the city of Evanston to have in their possession cannabis or alcohol when in certain places and in a vehicle. So both in their possession and obviously consuming it is also illegal. Particularly the amendments here are to Section B, which eliminates the requirement, eliminates, right now, Section B reads, consumption in vehicles. it is unlawful for anyone in the city of Evanston to consume or have on his or her person open containers of alcoholic beverages or cannabis products in or on any part of any motor vehicle, any motor vehicle. That's, what it says now. And I've also added to the public way. The problem with this is the state law allows for folks, and I'm sure many folks here have, gone to an event at a friend's house, a party at a friend's house. You brought a bottle of wine and with you, or someone gave you a bottle of wine that had been partially drunk while you're enjoyed while you're at a party, and you take that bottle of wine and you pop it in your trunk, and you drive home with that bottle of wine that has been opened. Right now, under our municipal code, it would be illegal for you to drive home with that that previously opened bottle of wine or champagne or whatever in your trunk, whereas state law would allow for that.
Whether you partook in it or not, because it could be you were with somebody that, drank it, right?
Sure, yeah. DUI law is still,
but I'm saying you
of
could
course.
just be transporting it.
Yeah, just transporting a wine bottle that had previously been opened, or, a cannabis container that had previously been opened, and you are then criminalized. Whereas, again, state code is very clear that it has to be in the passenger portion of your vehicle, and state law would still be in effect here, and would still be the law of the land. So people couldn't go driving around drinking beer or hanging joints out the window, but they could put it in their trunk and they'd be perfectly fine under state law. And then also it says have on his or her person in or about personal property. So on your person or in your personal property, your backpack, your purse, alcoholic beverages or cannabis projects in public buildings, parks, or beaches. So if a resident was, traveling from somewhere in Evanston, they stop downtown, they purchase some cannabis from MedMen, or they purchased some wine or whatever from the liquor store downtown, and then they decided to come here to pay their water bill, or they decided to just walk home along the lakefront or through a park, that would be a criminal offense. According to Consumption in Public 2, C2. So why would we criminalize someone? Again, if someone's consuming in public, if they walk into the building smoking a joint or drinking beer or something, they're still criminalized. They're still dealt with. But if they just have the product on them, they will not be criminalized. And I think, again, that achieves our goals of lessening interactions. The ordinance also goes on to add the purchase or possession of alcoholic liquor or cannabis products. So it makes it, right now, our code says that it would be unlawful for a 20-year-old to attempt to purchase alcohol. Again, I don't know if that's, in my opinion, I don't think that's something we need to criminalize. We need to criminalize the adult who sells alcohol to someone who's underage. We certainly want to confiscate alcohol or cannabis products from someone who is underage, but we don't need to arrest them for attempting to buy it, in my opinion. And also, this also adds, both alcohol and cannabis products. So right now, if someone under 21 tried to buy cannabis, they're perfectly fine, but if they try to buy alcohol, it's a no-go. And so this creates parity between those two substances. And then presence restriction, currently under our code, if you're 19 or 18 years old and there is a party, and you go to that party and other 18, 19-year-olds are drinking alcohol at this party, and you're not, you can be arrested, right? Because any ordinance violation is an arrestable offense. As that 19-year-old, you can be put in handcuffs and taken to our police department, not because you drank alcohol, but because you remained in the room where other people were drinking alcohol. And, and so I get what we're trying to do here, which is decrease underage drinking, but this doesn't seem to actually achieve the goal of decreasing underage drinking. It seems to only criminalize people who are actually doing the right thing and not underage drinking, and maybe even setting an example for their friends that, hey, you can have fun without getting drunk too. And so, again, I don't know if we need to criminalize young folks for that. And then lastly, pedestrians under the influence of alcohol or drugs. Again, if you are inebriated under alcohol or some drug in a manner that makes it unsafe for you to operate a bike, a motor scooter, or some other personal propulsion tool, whether it be like I said, a motorized scooter, we shouldn't have you on the street operating that vehicle. And so, because you can both put yourself and other people in danger by being drunk and driving a bike, or being drunk. And again, it's not just drunk. It's not like the state standard for driving. It's it's when you're operating it without in a hazardous way. So it has to be clear that you're operating the bike or the whatever it is, the scooter, in a hazardous way.
The point of clarification for this one, what's the change?
The change is that it's adding things like operating a bicycle, a motor scooter, and other things that currently aren't covered by state law, aren't covered by our code, to ensure that if you are inebriated to the point of causing a hazard to other people, that you are not operating those items on the public way. Oh. Okay. And then, well, that is it for this particular ordinance. So Councilmember Burns has his light on.
And so I just wanted to quickly, to expedite this item, hear any objections to any of these from committee members or Chief Eddington, because in the way it was described by Councilman Reed, this all seems pretty straightforward and non-controversial, but I want to hear from everyone else so we can see exactly which areas are concerning.
Thank you, Councilmember Burns. Councilmember Harris.
All right, I'll go down this. So the open container in the vehicle, I think, needs to exactly mirror state law, because the way when I first read this, I read this a couple times, it looked as though we were removing the open container in the vehicle, and I think if we mirror that, it makes sense. Like, you have to keep your wine, your beer in your trunk, or in the case of my minivan, in the non-passenger area, stowed away. That's totally fine. And it does make sense to not criminalize having things on you. You know, that I'm totally fine with that. Now, as far as the presence restriction and the attempt to purchase, I have kids. This is a deterrent, right? So, like, you don't want your kids to go to the liquor store and try to buy beer. You don't want them to go to the dispensary. I didn't catch this through the first read, but like the age 19, I think, is a deterrent for high school students to hang out with college students. And I think that's totally fine. I'm not sure. I'd like to see some information about how often this is used or how often people are arrested for this, whether it goes to adjudication. That stuff I'd not, as a parent would leave in. But yeah, those are my only points on that.
If I can respond very quickly to two of those points. So again, attempt to purchase. Would you rather your child have, maybe the clerk or someone try to reach out to you and let you discipline your child, or have your child be arrested for an attempt to purchase? And I think this idea that we want to use to, the threat of having someone placed in a cage and have handcuffs put on them as a deterrent to purchasing alcohol, when there's already a very clear deterrent, and that deterrent is that anyone who sells alcohol to a minor can lose their license to conduct business, and they will be held accountable. And then lastly, again, the same line of thinking with the presence restriction. Would you rather, as a parent, be able to deal with your 19-year-old who maybe went to a college party, your 19-year-old who's in college, let's say, who decided to go to a drinking party, and they didn't drink, they're a good kid, and the police bust up the party? Would you rather the police say, hey, your kid, Juan, was at this party. Your kid's a good kid. They weren't drinking, but they were still at this party, and they're not criminalized, and they don't get a record for being in a place where other people were drinking, and then you can deal with them and discipline them, rather than, again, them getting an arrest record. So I'll leave it there. I know you.
Yeah, just
And-
in
sorry.
response, because it's still, that was kind of my question. I wanted some time to respond. Is I think my concern about a lot of this is, and I would imagine Chief Eddington, correct me if I'm wrong, but this probably isn't enforced a lot, if at all. And because of that, anytime that's the case, what concerns me is that it opens it up for selective enforcement. And I'm trying to do away with that as much as I can in all areas of our municipal code. And so maybe, Chief, you can answer that. Is this something that in your time here, are we enforcing this?
Rarely, if ever.
Yeah,
And,
yeah.
But I would say that in this segments of this issue, the open container issue, I completely agree with state law sufficient.
Okay.
I think we do need some deterrence for underage people buying, and it's not solely the responsibility of the vendors and store owners. And we then get into issues of false IDs, which are quite common, and so I think that we still need some level of deterrence there. And is it selective? Absolutely. And once again, it's when we have that party that's really out of hand. There has to be something else going on. I mean, we're not. And if you've ever been to the enforcement of one of these from either side of it, there's usually a lot of running, and the policemen aren't going to chase everybody down. And so I'm suggesting that it's a tool rarely used, but it comes in handy rarely, but it's a tool that I would suggest that we retain to a degree.
And that reminds me of why we may have the disobeying a police in a public place or whatever,
Against the
because we
police.
could exercise that in that moment because they're clearly running away from a police officer.
There's resisting arrest already, and there's already crimes.
Well, I'm just saying that it just feels like what's really going on is the person is resisting or disobeying, and not necessarily just that they tried to buy alcohol. Which, if that's the reason why it's selectively enforced, it even more so, tells me that we may not need it. We may have other code and other things that we can use to address somebody that is fleeing after they presented a fake ID or whatever, or tried to buy, alcohol underage.
And I'm suggesting, sir, that our ability to run down teenagers is probably less likely to occur. I mean, I think if you've ever been in a situation where you're scared and you're running, you're a tough guy to catch.
Yeah.
And so my point is, we have an array of deterrents to prevent underage drinking because bad stuff happens when underage people drink. And so this is just one of the tools. Is it the be-all, end-all? No. Is it something we use every week? No. And once again, I'm looking forward to it at some point having the data so you can have it, whether it's at the council meeting or however this unfolds. I want to give you the numbers so you're fully informed when you make a decision.
Yeah, and I mean, this is one that I guess I'm less concerned about in comparison to the presence one, where you're not doing anything illegal other than violating this code that we have. You're not drinking underage. You're just merely in a party where others are, and you may not even be aware that you are. That one, for sure, I think I'm comfortable with and would love to. I don't see why that person who's not doing anything wrong other than violating this code, would be criminalized. This person is, in some instances showing a fake ID or trying to present themselves as if they're older. That's reasonable, although, again, I think we have other code that could address somebody fleeing, and so if every time if every time this happens, we're not arresting someone or ticketing someone for presenting a fake ID or trying to buy alcohol underage, we probably don't need it. And so I would love to see the data. If we're not enforcing it every single time, which I think is that's what I'm looking for, then we might need to look for another way, to see if there's other sections of our code that addresses it, so that there's there's not this much discretion if it's not necessary. So I would like to see that data.
I'm going to pass it to Council Cummings and then Councilmember Val has a light on. I just want to note that 15 ILCS 335-14B makes it illegal for anyone to knowingly possess or exhibit a fraudulent ID. And so the kid, I mean, if you go to the liquor store, they're going to ID you. And so that is where we can catch you. But simply walking up to a clerk and saying, I'd like to buy some beer. According to our law, that would be illegal, but under the state statute, you'd have to actually take the action of presenting a fake ID. Council Cummings?
I just wanted to ask a clarifying question and also offer some information to the committee. 3-4-11 of the city code regulates businesses against the sale of alcohol against minors. So that is built in. So we have both the folks under 21 deterrence as well as the business owners from not being able to sell to minors. It seems to me that the presence ordinance is clearly a product of the fact that we have Northwestern in town. So you have, I was a 17-year-old freshman. So you have freshmen and sophomores, some juniors that are at maybe like a fraternity house or something like that. And, you have some substances that are present that are lawfully there because there are people who are there who are 21 and older, but they're there. So I think that's probably, and I don't know when it was passed. I didn't look at the history, but I feel like that's probably what that is about. But the last question I wanted to ask was in the amendment to section C2, having on his or her person on or about or in or about personal property containers of alcoholic beverages or cannabis products in public buildings, parks, or beaches, notwithstanding those events that are permitted, so like concerts in a park or something like that, where there's maybe like liquor sales allowed or something of that nature. Do you want people going into Robert Crown or the Civic Center or Noise or anything like that for any other purpose other than something that's allowed to go on there, like an event? Do you want that to still, like somebody just be able to come into city council with an open container is really the question. Because I feel like that's what that language is also meant to curtail. But if you take that away, our public commenters can come in and smoke and drink in the council chambers.
Yeah, no, I mean, that's not an accurate description of what can happen because.
And real quick, as a quick response, I was going to say that there's, certain law, I wish I had a better example than conceal and carry, where there's certain public places where it's not allowed, but there's some places where it is. So I think we could carve out areas where it doesn't make sense, but I think some of the examples that Councilman Reed described do not seem, inappropriate or concerning, in terms of if you had, if you were carrying, cannabis in a container or alcohol. But I agree that some places it probably wouldn't make, we probably wouldn't want to do that. But there's other areas where you shouldn't be, able to be arrested for it.
Yeah, Councilmember Ravel.
Well, this is a multi-part problem here. So I guess for the first, I'd like us to clarify that we don't want the open containers in the passenger section of the vehicle. I mean, I understand that that's in the state law, but I think it doesn't hurt to have it. It fits. It'd be really nice to have it in our local code.
That has to be in the.
It has to be in the trunk.
Right. Yeah.
Right.
Or in the non-passenger, that's the way it's written in there.
However we want to word it, right. I'm not keen to have these open containers, et cetera, on our beaches and parking lots and all those other things, so I guess I like to keep that part.
I'm sorry, just for clarification, the ordinance still says you cannot consume any of these things.
Yeah, no, I know, yeah.
And so it seems like the only reason you'd have an open container of alcohol or an open container of cannabis would be to consume it. And so that would still be criminalized. And also I'll note that we may have to even come back to the consumption Because right now, we're about to, at a park, Arrington Lagoon, allow folks to buy wine and sit at that park and purchase and enjoy wine, which would be against this code as it's currently
Well,
written.
Except I thought there was a section that talks specifically about those kinds of events. Well, Canal Shores events for sure.
Well, I think was my point. Like, if there's a permitted purpose, right? If there's if the entity or person, there's a permit, whether it be special event,
Right.
whatever, that's different than your everyday possession.
Right. I'm happy to do away with the presence restriction. I guess it sounds like we should keep the attempt to purchase one. Pedestrians under the influence, yeah, we should add those new phrases. So I don't know if I've covered all of it. I have mixed feelings about these. Some parts I think we should keep, and some parts I'm happy to go along with the changes.
Yeah, well, perfect. What I want to do just for expedience is just make some of those motions to now. And so I'm going to move that we amend 9510B, consumption in vehicles, to say consume or have in the passenger portion of a vehicle, consume or have in the passenger portion of a vehicle, open containers of alcoholic beverages or cannabis product. I'm sorry. Consume, or have in his or her person, on his or her person, open containers of alcoholic beverages or cannabis products in the passenger portion of any motor vehicle upon the public way. Does that sound good to everyone? So I'll move that. Is there a second?
Second.
Is there any discussion on that particular amendment? All those in favor, say aye.
Aye.
All those opposed, any abstentions? That amendment to Section B passes. Great. Then the next thing that was raised is item 2, which is have on his or her person, public property, containers of alcoholic beverages. Councilmember Hedikaris, are you fine with that?
Which one is this here?
This is C2. So even if someone were to have a closed container of alcohol, a closed container of cannabis, they could not walk into the city hall and pay a water bill.
And just real quick, my concern with this is it's not realistic. That especially I think about people who are on bicycles to move around the city, and like they literally got to go home every time they make a purchase and then go to the beach, and it's just not realistic. We know people are doing this, so once again it'll be selectively enforced. It has to be. The young, African American or minority or person of color who's got cannabis in his backpack and he's walking or riding a bike, it's enforced on him, but not the countless people I see even on the lakefront every summer, not just not just with likely alcohol sealed, but open, contained openly and drinking, right? So it just doesn't feel like it's something that's realistic, and therefore it's going to be enforced selectively, and we know who's going to bear the brunt of that, which communities.
So you're seeing C1, you're seeing people doing that all the time.
We're talking about.
No, I know.
Oh, okay, sorry.
I'm seeing people absolutely. So that they have some container with them.
Mm-hmm.
It's concealed. You know what I mean? But it's not out in the open. But it has to come from somewhere. If you see people drinking and consuming at the lakefront, which we know happens all the time.
And so are you saying that we should not? So I'm looking at C1 before we get to C2.
Mm-hmm. Yeah.
So our C1, are we not making that change?
This is consuming, right?
This is consume or have
on your person.
or have on his or her person, or in or about personal property, open containers of alcoholic beverages. This means that if you can't walk down the sidewalk. If you had a bottle of wine and you just left a party, you're riding your bike home, you weren't drunk, you maybe didn't even drink. It's just your friends gave you a bottle of wine to take home with you. It would be against the law for you to walk home with that bottle of wine.
I mean, I'm fine with it. I mean, it's like Bobby said, like I have a bike sometimes, I have my groceries, have a 6-pack of beer. That's technically not Yeah, that's,
And so is part of this sealed and part of
But
it
they
is
aren't open.
Open? Because that's why I just need to understand.
Well,
I'm
this
probably
says-
fine with both, but.
This says open containers. Again, so this, the
Part of this
particular,
is open container.
Yeah.
You could take your beer bottles home.
yes, this would be for closed containers, or it's in your backpack, yeah.
Closed containers, I think, we could start there. Closed containers, everybody is fine with it?
Yeah.
Is that a change that we're trying to make here?
The ordinance doesn't contemplate.
Yeah, the ordinance, it's silent on closed containers, and number 2 just is any containers, whether open or closed.
Any containers, whether open or.
It doesn't say that, but because it says containers, it doesn't designate whether it's opened or closed. It means any container.
So by changing that, what will we be doing? That
When we take that away, there's no law against having a container that contains cannabis or alcohol. You can have your container of alcohol in your backpack and not be drunk, because again, we're adding a new change here that wouldn't allow you to ride your bike home drunk in a manner that causes a hazard, but you can ride your bike home with your bottle of wine in your backpack.
if it's open.
So
If it's open.
just,
or closed.
just a clarifying point for the committee. I'm sorry, Councilmember Reed.
Sure.
2 only regulates in public places.
Yeah.
Buildings, parks, beaches. So the idea that, the public way is not mentioned in the ordinance. So that's a little different, but being, the example that Councilman Reed gave earlier, I want to stop by and pay my water bill and I just left the store. That is one thing, but the point is it's the possession issue is within the public space, be it a building, beach, or park.
So the difference is public space being beaches and physical structures, way being like sidewalk, you're saying?
Yeah, and number 1, it contemplates, it mentions sidewalks, alleys, highways, streets, beaches, parks, all of that. And 2, it just says, as Council Cummings said, buildings, parks, or beaches. So you can't contain a container at all, whether open or closed, at any city building, park, or beach. But you can walk, I guess, with a closed container of that. So you can't enter a building with a closed container. You can't enter a building with a closed container, but you can, I guess, walk with a closed
You
container.
can walk with a closed container, but you can't go to a beach. I just want to make sure I understand.
So I could go to Benny's, buy a bottle, drive it in my car, but I can't bring it here into the Civic
You
Center.
can't drive in your car currently under the
If it's
open.
closed.
Sorry.
If it's closed, but I can transport it, but I can't bring it here into the Civic Center.
What about a beach, though?
I can't bring it to the beach, and I can't
If it's closed, right?
if it's closed. I
Okay,
can't
so
take
I
it to the
think we
beach
have
or
support to change that, is what I'm saying, for closed containers, and then we could deal with open containers.
Well, the open containers comes first, as Councilmember Ravel was pointing out. So,
Oh, okay. And I guess
I'm still not fine with someone, if you have a previously opened container of cannabis, again, the way cannabis is sold, it's usually in like some kind of twist cap thing that can be resealed. But once you open it, the seal is broken, and that's considered open, correct? Yeah, once it's been opened once and the seal has been broken, it is now open. And so if you break the seal on your cannabis, you close it back up, you put it in your backpack to go from your friend's house to another place, riding your bike, not intoxicated, whatever it is, that would be illegal.
Open container, you can't do it in the public way?
Correct.
Yeah, and I don't think that's realistic, if that's the case. Because people, of course, again, everybody is not in a car. People walk, people bike. They need to move. If it's a party they're celebrating and they're trying to get wine from their home to a friend's house and they walk or bike, we're saying that's illegal?
If it's been opened, yes.
If it's been open. And that's just not realistic. Probably a little bit more realistic for alcohol, although I don't think it is, but certainly not for cannabis, but probably not for both. It's just people are doing it. We know people are doing this.
So it seems like there may be support for even those 2 items there. I know Councilmember Ravel is a little hesitant.
I'm a no vote on number 1, but I can be persuaded on number 2.
What's one again?
One is that an open container, you can't walk down the sidewalk with a previously open container of cannabis, which I think is, again, that's going to be very selective, I think.
Because what you're saying is once you open it, you have to keep it in your home.
Yeah, once you open the container, you have to keep it in your
And
home.
I guess I'm thinking how many residents are there going to be in category A, meaning they've got their open bottle of whatever, and they're going to stop and sit on the park bench and have a swig, versus how many people are truly just going from point A to point B, and we're just criminalizing their walking home. I'm,
But
yeah.
to your point, if they do exactly what you said, which is stop at somewhere and take a swig, illegal. They've committed a crime, and that's covered by the code.
But we're facilitating it by saying they can walk around with their open bottle.
We're not really. I mean, we're making it realistic that we trust adults who have purchased alcohol to know that you can't drink in public, and I also, I mean, I didn't propose this change, but what are we so afraid of with people drinking in public? People drink in public. You can drink at a bar, on a cafe, outdoor cafe, on the sidewalk. You can drink there, but the second you step outside of the little physical boundaries, then all of a sudden you're committing a crime. And so why are we so scared of people drinking in public?
Well,
it's really about the behavior
people who are well-behaved and drinking are fine. It's the people who are not so well-behaved and...
which would be covered by disorderly conduct.
Right, okay. But you can talk all night, but I'm a no vote on changing number 1, and I will support number 2.
Yeah, I guess then to Councilmember Hadikatis, again, socially, I think alcohol is treated a little differently, that you probably would keep that in the, you probably would keep that at home. I'm sure that's not always the case, but, for cannabis, again, this is something that very often people are bringing it with them because they're going to a buddy's house, and it's the way it's going to happen anyway. And I don't want anybody arrested for that.
So I have a question for Chief Eddington, because open container, everyone knows what an open container of alcohol is, but it is, if you can clarify, like, does a loose joint in your pocket, is that an open container? Is that,
absolutely,
is it like a jar that's closed but the seal is broken? Because there's a million things now, like, oh, do you have a vape pen? Is your vape pen, does it have to be like zippered in a thing? Like, so this is new, right? So like,
even the sandwich bag is open because it has to be in its
original sealed package.
Right, so once it's cracked, I think.
Let's let Chief Eddington answer that.
All those are defined as an open container, except for the joint. That's if it's loose in your pocket, it's not anything. You're in possession of cannabis. If it's a big enough joint, you could get a ticket, but it's got to be a pretty big joint. But I think that a lot of the issues that we're discussing tonight fall into the periphery of like 1 in a million. I mean, I doubt seriously that you have complaints from your constituents about their backpack being searched while they were on a bicycle when we were looking for a bottle of wine.
Well, it didn't have to be in the backpack. It could be in their pocket. Even.
Sure,
which is a little weird too, that we allow the joint potentially, but not the.
No, we don't allow the joint.
You don't allow the joint?
No, the joint's definitely, because it's very clearly open. When you buy a joint from a dispensary, it's inside.
She said it depends on the size, right?
Well, and once again, whether we're going to take enforcement action.
Right, yeah,
and so I appreciate the time and attention you're spending on this, but I don't know that you're getting a lot of complaints from your constituents about our searches of their backpacks.
So you're saying you're not doing it already?
Once again, I don't want to seem like a broken record, but I don't have the data to share with you tonight to show you the magnitude of the perceived problem. If I'm not seeing it, Office of Professional Standards isn't seeing it, so I'm not sure, and that's why if I have more lead time, I can get the data, I can explain the data, and we're kind of doing this. The cart's kind of before the horse because I can't speak intelligently to what you're asking about because I don't have the numbers.
Yeah, no, I understand. Can
I go to Council Cummings? He's been waiting for you.
Oh, I'm sorry, I didn't know that.
I just wanted to very briefly, this goes to, I guess, what a bygone era policing would to talk about quality of life issues, right? They were trying to avoid folks walking up and down the street with open containers, brown paper bags, that sort of thing. But also because, again, we're a college town, you have people leaving various facilities on Northwestern's campus or maybe even off campus where the activities have spilled outside on their way home or back to whatever dorm or apartment or what have you, just to offer that context to the committee. So all of your examples are well taken, but on the flip side of that, there's probably some reason why this was written this way back when it was written, and those are other instances that could be potentially possible as well.
And I just want to make a difference between like something that is concealed and something that is out in the open. So you could be not consuming, but walking down the street with clearly an open, bottle of wine. And I'm not saying that that should necessarily be allowed, but if somebody has it in the backpack, should that be allowed? Can we even search the backpack anyway, which is a whole nother thing? And then, but if it's in the pocket, which is also more so what I'm concerned about, which is revealed in some type of investigative stop, we're doing a pat down, and you're flipping pockets, which happens, and you see a cannabis in a container. We're saying you can charge somebody based on that discovery in the moment, right? Or no?
It depends on the rest of the facts and circumstances. I mean, do they have a medical marijuana prescription? I mean, this is very complicated.
But now it's adult use.
Recreational. So I mean,
it's adult use, open for adult use now. It's not just before then I would understand that, right? Do you have a card, et cetera? Now it's you can legally. There's an adult use program, so as long as they're of age, and you find that they could be charged for it under the current law.
But once again, I don't think we're levying that many charges in these fact patterns that you're talking about. Our arrest for cannabis, I think the couple I saw last week on the bulletin were for large amounts of cannabis in a car, clearly dealers. I don't know, I don't have the data in front of me, but I would be surprised if there's a sizable number of arrests in the fact patterns that you're talking about.
And if I can just interject, I think regardless of if there's 1 arrest, 20 arrests, 1,000 arrests, there shouldn't be a single arrest when we've made cannabis available for adult use if you walk down the street with cannabis. But I do want to continue.
And real quick, just one last thing is if it's up to a certain amount and somebody finds a loophole and they say, okay, if we were to pass this, I can, as long as I have it in its original containers, I can have a bunch of original containers, but I'm delivering, right? And I don't know if that's the concern, but I would even be fine if it was up to a certain amount. But I think there is a reasonable amount of cannabis that you should be able to transport in the original packaging, but open, without it being discovered and you charge for it in an investigative stop. That's what I'm saying. And I don't know if I would like to see the data of whether or not it's happening, but almost the fact that it could happen, especially in a scenario that we know happens all the time, which is young men, especially younger men or any young people especially are, stopped often. And we know the amount of investigative searches that happen to that particular population. So this is something that maybe it's not reasonable to expect it to be discovered in a backpack, but certainly if it's in somebody's pocket, which could happen. And I'm sure does happen. So, I mean, the data will be useful, but I just wanted to make that clear.
And it could even be, as we just said, if somebody's riding their bike on the sidewalk in a D1 district or something and they get stopped for that, their backpack can be searched, then they can find the cannabis in the backpack, and it creates another scenario where, they have an added charge. But I do want to continue on and move down to where there was some disagreement, and it's the attempt to purchase. So it seems as though, Juan, were you satisfied with the fact that our municipal code, as Council Cummings said, already criminalizes the sale of alcohol and cannabis to minors? And was there something else that you added, Council Cummings?
Just to be clear, I'm not 100% sure about the sale of cannabis in our code.
Oh yeah, the sale of cannabis isn't covered in our code, but or I don't believe, to my knowledge, it's not covered, but certainly alcohol is.
Correct.
And cannabis just isn't covered. I'm sure it's covered by state law, but are you satisfied with the fact that, one, the attempt that it's already a criminal code for someone to attempt to buy alcohol or for someone to sell alcohol to a minor, and it's already against state law for someone to present a fake ID in order to facilitate that? So the two things that would be necessary for that to actually happen are covered by law. Is that satisfactory to you?
I'd want to hear from legal if this helps adjudicate like cases with minors, as far as like using this attempt to purchase for like a small violation versus the state code?
So I would not have that information. I think that's probably another question we can ask the police department to provide. However, it does provide an alternative, in theory, alternative to arrest, although one can be arrested for an ordinance violation. It does provide an alternative to arrest to write them an ordinance ticket instead.
But it doesn't really cover, if someone presents a fake ID, that's not covered by our ordinance.
Correct.
And so it wouldn't provide an alternative. And in fact, it's already covered by our ordinance, the sale of alcohol. So the only thing this adds is that in fact, it doesn't create an alternative. It creates a new charge that someone who, again, merely attempts without presenting a fake ID, without doing anything that could really get them alcohol, a 20-year-old walks up to a clerk and says, presents them with a bottle, and the clerk asks them how old you are, and they're like, I'm 20. And they say, oh, that has alcohol in it, you can't buy it. They'd be criminalized.
They didn't try to steal it.
They didn't try to steal it, yeah.
So by deleting the attempt language, they actually have to complete the purchase in order for it to be criminalized.
Yeah, so it's criminalized if they purchase alcohol. So if they go and they buy alcohol with the fake ID or whatever it is, they are criminalized.
If they get it,
if they get the alcohol, then they are criminalized. So it's still illegal for a minor to purchase alcohol. It's just not illegal for them to attempt.
So hold on. So if they get it,
they would still be liable under this ordinance. So if you purchase alcohol and you're under 21, you will be liable for this.
It's just because you're now an underage person.
You're now, yeah.
Yeah, alcohol that you just
But the
purchased, that
attempt.
makes sense. Yeah. But the attempt, I would, and I don't know if Councilmember would agree with this. Again, I think we just need to, in some instances, we need to cut out the discretion and just say it's a ticket. Like, we're not saying there shouldn't be nothing should come of it, but maybe it should just be a ticket and not an arrest.
So are you fine criminalizing just the purchase and not the attempt? It's still illegal to purchase. You can still tell your kids, hey, if you buy alcohol, you're going to get arrested.
I worked at a liquor store, and so I have a lot of here in Evanston, and I don't think we just turn kids away. So I don't know, I would like to see the data, but it doesn't say arrest in here currently though.
We established that any ordinance violation is arrestable.
And that's what I'm saying again. I know Councilman Reed probably wouldn't agree with this. He just wants probably a clean, but I don't mind for some of this if it's a ticket. And again, I know Councilman Reed probably doesn't agree with that. But
Please don't speak. I'm fine. My goal is to stop arresting people.
Okay, yeah, because I want to be clear that some of this stuff, if we want, if you mentioned that you want some deterrent. I mean, there's some stuff I just
can we let Councilor Cummings interject, because it seems like he might have.
I was going to say then I think Councilmember Burns' point is well taken. Then it raises other issues that we can discuss out offline. That if the point then is to stop arresting people, then you just make it clear that ordinance violations should be issued tickets and not subject to arrest regardless. And I certainly don't mind amending language and making it clearer, more concise or whatever. But the fact of the matter is, if you're trying to curtail arrests for ordinance violations, the better solution may be then to essentially make the penalties for ordinances to be tickets, very specific, and not arrests.
Such as we do with cannabis. I will say that these particular things, so the main goal is to prevent arrests. There are some things that just government should not be interjecting into your life, giving you a ticket or anything for, again, things that we already discussed. But
sounds like for this one, Councilman Hadikaz may want some deterrent, and so I'm saying specifically for this one.
So are you fine if I will make the referral tonight to create a ticketable offense for any minor trying to purchase alcohol? Would that satisfy your? Okay, but we'll strike for attempting to purchase is a ticket. Purchasing would still be a crime, but we can eliminate it here. And then the final thing was the presence restriction, which we create kind of a weird dynamic because Councilmember Revelle said she was fine with eliminating the presence restriction, but then not fine with other things. So there may be a no vote on those others because of those other things. But then Councilmember Harry Karas, I just want to see, are you fine eliminating the presence restriction? And if we want to make a ticketable.
Yeah, she's fine with
No, but she's not fine with other stuff. So that may lead to a no vote. And so I want to make sure, Councilmember.
You vote on it separately.
No, it's all one. ordinance.
Why can't we separate it out?
I mean, I don't know. We don't need to.
If you have support, I mean, I guess it doesn't matter if it'll pass, but which is maybe what you're getting at. But I don't see why we can't separate it out.
Yeah, I may have, when I made the referral, put them all in one thing. I don't remember if I made each of these individually as a referral.
Council Cummings, is it that difficult maneuvering to separate these out?
It would be cleaner if they were separate. However, you can, through parliamentary procedure, move to adopt or recommend to council sections 1, section 2, section 3 separately.
Okay, let's do that. But I still want to. But I believe in the democratic process. I'm trying to work in the concerns of as many folks.
Pass the ones that we have support on. That's what I'm
okay, and then we have support on the last one. So all right, so let's do it like this.
So just so you have a clean record, Councilmember Reed.
Well, let me first, I'm sorry, if I can just ask, Alderman Herrikaris, are you supportive of eliminating, similar to Councilmember Ravel, the presence restriction?
If I find out we don't, maybe if you make it ticketed, I don't know.
But you're willing maybe to, at least for now, move this forward to council and then
forward. I might change my mind, but that's not the,
okay.
Other stuff has to be cleaned up, but yeah.
Okay, well, we'll look to fix the presence restriction if we need to. We'll work to get it, either referral to make it a ticketable offense and maybe address it better than just 19-year-olds. And to your point, you said you don't want high school students going to parties, so maybe we make it folks who are 17 years and younger can get a ticket if they're at a party or something. So we can figure that out. Okay, so seeing that, it seems as though all of the concerns have been addressed, at least for a majority of folks to vote for it here. And so with that is...
If we separate it out here, though, it'll be separated at council, right? Which I think is important, because I think at council, this is going to get even more difficult to pass each one. And so instead of trying to do that there, I would rather do that here.
Well, I think that even at council, once we create the ticketable offense for the other items, that, a reasonable number of folks would be supportive of it.
I mean, it's up to you, but I think it would be helpful to separate it out, but however you want.
What I was going to point out, you've already made an amendments to portions of section 1 with respect to the consumption in vehicles. And then I'm not sure where the committee is going to land in terms of consumption in public, but I would, just for the ease of, for us to try, the law department, to try and make sure this is on the council member agenda correctly, each section probably should be parsed out and appear on the council agenda separately.
Yeah, we'll do that. Yeah. Okay, so then I will entertain a motion specifically to adopt.
And to that point, I'm sorry, there'll be separate ordinance numbers then.
Yeah.
Going forward.
Yeah. So to adopt 9.5, what's presented in front of us, 9.5.10, with the amendments that were previously made, 9.5.10, A, B, C, D, or really just all of 9.5.10, with the amendments. So it's moved. I've moved it. 9.5.10 is the first part.
Can we review what we did? So
Yes.
Yeah.
So with 9.5.10, we amended what's here on the language to say that, B, to say consume or have on his or her person open containers of alcoholic beverages or cannabis projects in the passenger portion of a vehicle. That was the amendment there. And then everything else was left the same.
Councilmember Reed, so that I can get this correctly, is
Yes.
this portion mirroring what we have in the state code with the passages?
Yes. For the yes. Specifically the language about passenger portion or whatever it is in state law. Okay, so then may I have a motion on item 9.5.10? I'm moving it. Can I have a second?
Second.
Moved and seconded. All those in favor say aye.
Aye.
Aye. All those opposed? You said you supported this stuff. Okay, that's fair. Okay.
What's still in there?
One is still in there.
What is that again?
consumption in public, having open containers of
Oh, yeah.
alcohol. So I'm
I'm
going to stand in the 7th Ward outside of places where they serve alcohol. I'm going to start snitching on your residents the second they walk onto the public street with their container, and so we'll see how much folks like that.
So
Okay.
to clarify, that was section 1 of the ordinance, Councilmember?
Yes,
Reed?
that was all of it. So all of 9510. And then we're going to go to 9510-1 is next.
So all the 9.510 just passed.
Yeah, all of 9510 just separated out and passed individually. Now we're on 9510-1. I move the approval of 9510-1, which is as it appears, and we've gotten clarification from.
Just say again what it is for the public.
Yeah, purchase, possession, or acceptance of gifts by persons less than 21 years of age, consumption by persons less than 21 years of age. And so this would add cannabis products. So this would make it illegal to give someone 21 a joint, under 21 a joint, or some other cannabis product. Even if you gift it to them, it'd be illegal to gift it to someone under 21 or to sell it to them, of course, and it'd be illegal for them to consume, and it would be illegal for someone under 21 to purchase alcohol. And I am going to put in a referral that makes it a ticketable offense to attempt to purchase. Okay, so it's been moved. 9510-1 has been moved. I just want to make sure, is there a second?
Second.
Seconded by Councilmember Burns. All those in favor?
Aye.
Aye. All those opposed? Any abstentions? It passes unanimously. And then there's presence restriction, which is 9510-2, which we're striking this. I move 9510-2, presence restriction that makes it illegal it makes an arrestable offense for someone under the age of 19 to be in the presence of a place where alcohol is consumed. Is there a second?
Second.
All those in favor?
This is the presence, right?
Presence restriction, yes. All those in favor?
Aye.
Aye. All those opposed? Any abstentions? Great. That passes. All right, that brings us to 9510-3, pedestrians under the influence of alcohol or drugs. This is the portion about you can't be impaired to a point that you cause a hazard and ride a bike or a motor scooter or some other, some other equipment that is covered. And so let me I want to make one amendment to this. It says propulsion tool. I would say equipment. I was maybe very tired when I wrote this, and I should have said equipment instead of tool. I may have entertained a motion just to clarify, to make it better, to amend that to equipment.
Do we need to vote on that? Can we just say yes?
We can very quickly second it. Huh?
Yeah.
Okay, friendly amendment, and it's adopted. So we're amending 9510-3 to instead of propulsion tool, equipment, or we'll even let the law department, if there's some better word that you think, will leave you the freedom to amend it in the way that you see fit. Okay, so all those.
Is this meant to get, I'm sorry.
Go ahead.
Is this meant to get sort of those, I don't even know if they're skateboards, but including skateboards, are you talking about, like, there's these.
Like e-scooters?
There's one big wheel in the center, but like you can rock back and forth on them, and that's how you move?
Any of that, yeah. It's meant to get to all that. You can't operate.
Definitely that.
Yeah, especially that if you're
fast.
Yeah. So all of that it's meant to get to.
Got it.
Okay, all those in favor of 9510-3 as amended?
Aye.
Okay, great. The motion passes.
Real quick, what about walking is already covered, obviously, right?
Walking was already covered,
I'm
and
just curious.
now it's including other things.
Yep.
All right, we're going to try to move quickly through the last few of these. If we can't get to them all, then we will we'll
Was
move
there anyone
on.
that's easy? Like there's some.
Yeah, burglars tools. I want to go to that one. HS 11. So I move HS 11, removal of burglars tools ordinance from the city code.
Second.
And that last one was one of the most complicated, a lot of stuff. So the rest of them are kind of straightforward, just single sections of the code.
Maybe not HS 10, but we'll see.
We'll see. All right. But this is burglars tools. So this eliminates the section of code relating to burglars tools. with this one, we discussed it at the last meeting. The law department provided a memo. It seems as though we cannot regulate a felony as a misdemeanor, but we can regulate a felony as either a misdemeanor or a felony, but we can regulate a felony as a ticketable offense, or essentially that's what the memo.
You can't regulate a.
You can't downgrade what is already a state felony to a misdemeanor.
Right.
But you can make it I'm forgetting the term that was in the memo, but essentially you can make it a ticketable offense. And I'll look for the language.
Make what is a felony?
What
at
is
the
a
state
felony?
level, a ticketable offense here?
That's what the packet says. I'm happy to
Give me
just.
1 second.
Yeah, okay. I mean, my goal is to strike this, but if we are able to do that, then I'm happy to amend this to make this a purely ticketable offense. Or amend the language to match state law, and then also.
I was going to say, because there was another change.
Right, yeah, to make it match state law and be purely a ticketable offense.
And Councilmember Haddock, if I remember correctly, you were okay with that first part of that, as far as making sure it matches this.
Yeah, I think there is, in the current code, there's just the last line where you basically have to prove yourself innocent, was the part I had an issue with. And the state law, I have it right up here. It says, yada, yada, with intent to enter such a place or with intent to commit therein a felony or theft. So if you're caught red-handed with a bunch of tools trying to get in someplace, you can get fined in this way. And I think if we just mirror the state code, I think that makes more sense.
And yes, I just found the memo, and that was the recommendation, because I think there's some trepidation by our department that the way that it's currently drafted is actually not proper, and we could, if it was challenged in court, we would actually get thrown out. So there is the suggestion from the law department that it be that it would mirror state law in terms of possession of burglar tools.
Yeah, so I just want to note that the reason I brought this up, because again, this is another very warped Evanston Now article. No, Evanston Now readers, I'm not looking to allow burglars to run loose throughout Evanston. It's looking to address this law in a manner that comports with our Constitution. And as our law department has said, the city of Chicago has had a similar ordinance that was struck down by courts.
And because of how the law works, in theory, ours is
also invalid.
Yes.
Right now, as it stands, ours is invalid. So even the person who was charged with it, that we were, saying that person shouldn't have been charged with the local ordinance. And that's also, I will say part of why I have a bit of concern about local ordinance violations is our local adjudicators don't have the same, I'm not going to go. Courts, I think, are more attuned to court precedent. A judge is more attuned to court precedent than an administrative hearing officer. I think on average that might be true, because
I think to clarify that, our hearing officers may not be attuned to prior administrative adjudications of our own code, so precedent of our enforcement of our own code, but they would be attuned to stare decisis from the courts, because they are licensed attorneys and practitioners.
When was the Chicago case decided? Do you remember that? And while he's looking that up, Chief Eddington, do you remember when the young man that you were referring to was charged with the local ordinance violation?
I believe it was in the last 2 years, sir.
Okay, thank you.
This was the case that was cited in the memo was from 1970.
So we have a law in the books from 1970, and sure our people are aware of stare decisis, but apparently this law has been unlawful since 1970, and it's been enforced here in Evanston unlawfully. So I'll just say that.
So is it clear now, the other part of it, which is whether we can, it will become ticketable, or where are we at on that part?
What the law department says is that, yes, we can make it, and Nick, can you give the exact language that is in the memo? I'll look for it as well, but that we can make it essentially a ticketable offense. They use the term.
Ask the question one more time, I'm sorry.
Yeah, hold on.
You can make a felony.
We can't make it a misdemeanor according to the memo.
But we can make it ticketable.
But we can make it let me use the correct term that's in the memo. It's essentially ticketable, but the word is slightly
So
different.
our ordinance allows for it to be ticketable. Unlike Chicago's ordinance, which is in the memo, it does not account for jail time. Chicago's ordinance accounted for jail time. But it's recommended that our ordinance mirror state law, which is 720 ILCS 5/19-2, with respect to possession of burglar tools, and still make it ticketable, as opposed to our current reading, because it was somewhat similar to City of Chicago's ordinance. And for everyone's edification, our ordinance was passed in 1957.
Yeah.
But under state statute, what is the penalty?
It's a felony.
I'd have to look that up, but for some reason I have the sneaky suspicion that it could also be a misdemeanor.
As I said, I don't see how we can make what is a arrest. This is what I'm trying to get at. We can make an arrestable offense a ticketable one.
It's a felony at the state level, and that's why we're having this discussion. So it's a felony offense at the state level, and it says, what it says here in the memo is, therefore, the city may regulate for the protection of public health, safety, morals, and welfare, but may not go beyond the limitations that have been established by statute. That means that the city is authorized to pass and prosecute ordinances dealing with criminal acts, but the ordinance cannot be inconsistent with the criminal laws of the state. It cites the law there. Subsequently, it can be inferred that municipalities may regulate an act to provide for punishment, but may not reclassify an act determined by the state law to be a misdemeanor, and make it a felony, and vice versa. So we can't make something that is a misdemeanor by state law a felony. We can't regulate felonies, period. And we also, from what this is saying, we can't take something that is a felony and make it a misdemeanor.
I know that. That's a big deal.
To do so would be inconsistent with the criminal laws of the state.
Can't reclassify it.
Yeah, there is no case that is on point with the particular issue. The state law does not preempt the city from making its own ordinances as it relates to possession of burglars' tools. It is advised that the city not attempt to classify the possession of burglar tools as either a misdemeanor or a felony, but it may choose to impose a fine.
And what I'm trying to get at, so this is true even for felony
Drug possession.
charges, for example.
Yeah.
That's what we're saying here? That's
what we're saying, and I'm very happy that we're saying that, because a lot of people are talking about diversions from arrest, and
Very interesting.
let's
But thank you,
divert
Councilman.
arrest and create
All right,
local.
so where are we at on this again?
So then I make a motion to have this code mirror state law. Is seconded by Councilmember Revelle. All those in favor?
All right.
So wait
Sorry.
a second. Sorry. The
Yep, you're
ordinance
fine.
before the committee in the packet is to actually strike burglars' tools altogether.
Yeah, but we're amending it to mirror
Just
state
want
law.
to be clear.
Yeah,
because- So I have the right direction to.
Yeah, and then I'm getting there now, so one motion at a time. And then now, my second motion is to make this, and Nick, just as an example, how would we make this a purely ticketable offense where someone could not, for example, be arrested for it?
We would have to craft language that would say that the consequences of, someone being in this possession or committing this behavior would be fined this much, et cetera, et cetera.
Okay, then I move that this offense be merely a ticketable offense with a ticket not to exceed $750, and not to exceed $700, to have a minimum of $300 and a maximum of $750. And I'm picking those numbers to be consistent with the way we ticket for certain other offenses. Because this is a very serious offense, and I do think it requires of the highest ticket fees that we can assess if we're not going to criminalize someone for it.
Which is highest is typically 750.
750 is the highest that we can go by state law.
Okay.
Is there a second on that motion?
Second.
Is there any discussion on that motion? Is there anyone opposed to that motion? Okay, all those in favor say aye.
Aye.
All those, any noes, any abstentions? It passes. All right, so we've gotten that. And then I think we'll move on to the park issue, and we'll, so that I move item, my apologies, I move item HS6, modifying portions of City Code 710-2, park hours in operation. Is there a second? Seconded
Just
by-
real quick, we're at
Second.
The second is there, but we just have HS 6, 7,
So remaining now, yes, HS 6, HS 7,
9, and 10, and 13.
9, 10, and 13. So we're not going to go through all of these tonight, but we are going to try to get through a few of them quickly, if possible. Okay, so HS 6, Ordinance 59022, modifying portions of the City Code 710-2, park hours and operation. Councilmember Harry Carson, I'll start with you.
So I will try a friendly amendment where you had the language that said exercising, change that to jogging and cycling.
I am happy to amend that. So we are striking the language, as Councilmember Harry Carr said, that says exercising, and we are adding the language to say specifically jogging or cycling, correct? Great, okay. I would like to just take a voice vote on that. I second it. All those in favor? Aye. The ayes have it, great, okay. We've officially done that. Okay, are there any other amendments? Great. Councilmember Ravel.
Well, so one noise problem that doesn't seem to be covered in any of this is the use of basketball courts.
Yes, that is a good observation. You're correct. It is not covered in this section of code, but in another section of code, it does say specifically that all courts close at 10 p.m. And that's also why I'm moving up the hour here from 11 to 10 to just match that it's clear that at 10 p.m. you're not playing basketball, you're not hanging out in the park, you're not doing anything other than walking, sitting, cycling, or jogging.
And so what part of the code is the basketball court part?
It's a separate section. Let me try to pull it up, or if Nick can pull it up, I'll try because I've read it in the past.
And it's not just tennis courts, it's basketball courts.
It's all park equipment. So all basketball courts, tennis courts, even the little exercise things that are along the lakefront, you're technically not allowed to step on those after 10. And Councilor Cummings we'll give him some time to confirm that, and I will also look for it. Are there any other questions that you have?
Well, and I guess I am concerned about even groups of persons making
Noise audible from a distance.
It's a real problem over at Lighthouse Beach, and I just I don't think I can support allowing even.
Just doesn't speak to that. I thought it was only you.
Well,
could
currently,
ride, walk.
go ahead.
I thought this was just you could cycle, walk, or sit.
Well, presumably if you're walking with a group of people through the park, or you're sitting at the park with a group of people.
Because we have people who come and sit, but then they I don't know. I'm not comfortable voting for this.
And so I want to get to your concerns. So, first, Council Cummings has turned on his light.
Hours of play in basketball courts under 7-10-3G is 8 a.m. to 9 p.m.
Oh, 9 p.m. even earlier.
On basketball courts.
Okay.
Just basketball courts? What about tennis courts? And
tennis courts do not have a regulation with respect to that.
Isn't that interesting?
You're not allowed to use a skateboard on the tennis court, but there's nothing in terms of hours of play listed in the city code. It does only restrict, in terms of hours, posted tennis court rules and regulations as adopted by the Parks and Recreation Board are what govern. And only tennis is allowed to be played on tennis courts.
you know what's interesting about that is I see people in certain tennis courts in Evanston playing rather late. And I think that's the 7th Ward on Lincoln. And,
At Leahy?
Yeah, exactly. They play pretty late over there. Okay, but
Yeah. Councilmember Revelle, did you have any other questions?
No, it's just, I just have a real problem with allowing people in the parks after closing hours. At Lighthouse, that just would create a problem.
Are you fine with cycling and?
Yeah, we've adopted,
We did that already?
yeah, we've adopted member Harry.
Oh, that's what we
Curtis's.
just did.
Yeah, we just adopted
That was the
his.
cycling, just the cycling one?
That allows for cycling, jogging, walking. His amendment is to add cycling and jogging and to eliminate
Oh, I thought
the
that
kind
was-
of
I'm sorry, okay.
vague term of exercising and to make it very clear what the exercise is.
I thought that was the amendment, but we've
Yeah,
passed
that was the amendment and it was passed.
Okay.
Okay, I will,
Just to be clear, we're looking at sitting.
right now, the ordinance that we're looking at would include, would allow folks it would ban anyone from a park. So no one could enter a park after 10 p.m., whereas currently it's 11. And, we know about circadian rhythms that people start to go to sleep around 10. That's your natural kind of wind down sleeping time as we're nearing. And from 10 p.m. to 5.
I mean, it's not a winding down time for 22-year-olds.
Well, and hence why the law says that you cannot enter a public park to do anything other than sit, walk, or jog or cycle, and that if you enter the park for anything other than that, you're not allowed to enter it. And if you enter the park and you are in a group of people or even by yourself and you're making any noise, it's not decibel. If we can hear a whisper of the noise that you're making from 50 feet away, you are to immediately leave the park, shall not remain in a park from 10 p.m. to 7 p.m. So if we can hear you whisper 15 or 50 feet away,
Does that make it consistent with our noise ordinances after hours?
It's too different.
No, because 50 feet is used, I think, in.
I do believe, I think I got this language from, I also want to note that this is, ordinances like this exist in many cities across America. And in fact, I got this language, most of it from Ann Arbor.
Because my point is that, again, if you're in the backyard or whatever, partying, loudspeaker, whatever it is, like there's a time limit, but if you're sitting there of a certain volume, you could do that. It just says, and this happened in my ward, where they come by the gathering. You can still gather, it's private property. It's just the noise can't be heard, and I'm pretty sure it's within 50 feet. So this is consistent with what we do in residential dense areas already,
It's not just merely the noise, it's the young people show up, and one thing leads to another, and then we have fires in the dunes, and I know none of this is allowed, but it's just, I don't want to encourage people to think they can stay in the parks and go on the beach later. I like the idea of closing it at 10 p.m., that helps, but I just can't. I would like to close the parks at 10 but people still can't go there.
I do want to note that I'm going to let Alderman Harry Cars go.
Just for the second time, Councilmember Harry Cottage, where are we at on this?
There's beach hours. So beaches close, I was just looking this up, at 11 p.m. So
And this
I
won't change that?
think beaches are, that is a good distinction. Are beaches separate from parks? Maybe Audrey can speak on that.
So our beaches currently close at 6 p.m. When we get to our regular season, they will close at 8. So if you're talking about the parks, it would be 11. I would also warn you all that we still have some events in our parks that are permitted currently after 10 p.m. So they already have, that's an obligation that we've made to them to allow them to be there after 10. So if you're going to change the park hours tonight, or even soon, and when those park hours are 10:30, some of them until the season is over.
So folks are, sorry, go ahead.
Oh, Audrey, since you're here.
Sure.
How do you feel about the provision to sit or walk or jog?
So I don't think that it's much difference than, I think it's a change in semantics, but I don't really think it's any different than keeping the park open 24 hours a day. So there was, I don't know that you all read what came from our Parks and Rec Board Chair, Mr. Bush. That was a public comment that was sent in, and we haven't changed our position on this.
And just so I'm clear, I think that I know there's might be some difference of opinion on this, but what I want to make sure is that if somebody, the scenario I have in mind is if it's a small group of people or down to one person walking through a park, jogging through a park, cycling through a park, I see no issue with that. If there is a large gathering at a park after a certain time, obviously that can create some issues. But everything else shouldn't be criminalized because we're concerned about really larger events, and less people moving through a park, but more so like hanging out in a certain area. And again, I know there may be some difference of opinion, but if there's not enough support for the hangout, is there enough support for the cycling, for the walking,
And I want to note that if a group of people are together, a group of young folks, they're going to be making noise that's audible, even if they're being fairly quiet. A large group of people is going to, just the hum of the human existence is going to make enough noise that's audible from 50 feet, thereby they are to leave the park. To them, the park is closed. Now, if there's a group of young people who happen to be so mouse quiet that they're there and you can't detect noise from 50 feet, well then, really, what are they doing that's bothering anybody? But I think that your concerns of a large gathering of folks, those folks will still have to leave the park immediately if an officer comes over and as they're approaching, they can hear them 50 feet away, even just a hum, audible, not audible at 65 decibels, 75, it's audible, period, and you got to go. Okay. Councilmember Herdicaitis? Councilmember Herdicaitis, where are you?
Oh, that my light was on from before.
No,
I just wanted to ask Audrey.
Where are you on this? Just because I may change this if you're not going to support it. So where are you at on this? Are you a no, as it's currently written?
I mean, I wish park staff would support this. I do feel it is problematic to have it be criminalized just to be in the park. Like, I know, me personally, I've ridden my bike through the parks early in the morning. I think just leaving that open for people to do would be all right. But
I'd rather make some progress than no progress. So if we're fine with cycling in some portions of this, I'd at least like to adopt that today, because we know what's happening, as you said.
I think
People
cycling and walking
walking.
and like sitting, but like, I agree, maybe take out the gathering of people. Like,
I just want to be clear that we're not condoning, the exact issue that you're concerned about, this actually addresses. Because if we take this out, then what's stopping a group of people? A group of people can go and walk or sit and do whatever they want in the park and essentially make as much noise as they want in the park. This says that if that person or group of people makes noise that's audible from a distance, they got to go. This actually addresses the very issue that folks are concerned about.
No, but I'm not interested in the first part about.
Well, maybe not you. I'm looking at maybe Harry Carr.
Concern is sitting, and so are you concerned about the sitting as well, Councilmember Herdicaitis?
No. Oh, the one thing I didn't know before is the fact that we have things scheduled that a bunch of these changes would interfere with.
Then I'm happy to shift it to 11. If we're fine with people being in parks now at 10 o'clock and making noise, I was looking to, solve the issue of residents who want to be able to go to sleep at 10 o'clock or, somewhere around 10 and have that noise cleared out well before 11. And so that's why I think the 10 o'clock, ending this noise, and we can add a provision except for, events that are authorized by the Parks and Rec Department.
So, to your point, Councilmember Herdicaitis, if you're riding your bike through the park, even if the police were called, by the time they get there, you'd be gone. So, but if you're continuously just riding and exercising, I think it brings, again, as I stated the last time I was here, I just think it brings up a lot of issues of miscreant behavior. If you are, because to me, the ordinance that you've rewritten says the same. The parks are open 24 hours a day. So our position still remains the same. because there is no difference except for that you've added some language. The summary of the ordinance change is that the park is open 24 hours a day. And so for someone saying, hey, the park is closed, move along, you can't do that anymore. So I just want you all to understand that that is gone.
Yeah.
So all of what we discussed of like bringing this back to the park, the same thing we discussed last time is still here. And that's what our Parks and Rec board chair provided in his statement.
Thank you. If I can quickly address that.
I'm pretty sure the way I understood this is it talked about walking quietly through a park, cycling quietly through a park, through, not in circles, but through a park on your way home, for example. So I just want to be, I'm fine not having the sitting and the gathering and all of that. I don't need it. I'm fine with it or without it. What I want to make sure is that people can walk quietly through a park, can cycle quietly through a park. I would like to at least make that progress tonight. And if we have enough support for everything else, that's fine. I can go either way. But we know people are doing the through the park quietly, and we should allow for that,
And thank you. And I just want to note that, yes, if I were to ride my bike through the park, that maybe if there wasn't a police officer around by the time I've made my way through the park or along the lakefront, maybe by the time they arrive, I won't be there. But there could be an officer just sitting there and see me riding my bike or see some young person riding their bike. And, that person is then, it creates an interaction with law enforcement for an issue that is not harming anyone. And, again, I think that the language here, there's a big difference. Before, and I did not write the previous language, that referral was made before I started drafting the ordinances, but there is a big difference. Before, the ordinance just blanket said that even city buildings aren't, closed, and park buildings. This very clearly says that, the park department may set a time for all buildings to close, and buildings can close at whatever time you say is appropriate, park buildings, but the public area of the park is still open. And I want to bring this up. I think first.
Can we just check on where Councilman Radicakis is? Because I want to move on if we can. I mean, if you're fine with this, then we can go. But and it's still going to go to council, obviously. We can still, Okay. So let's just call it.
The staff is not on board, that change is not new with things, because I think we need to get on the same page with hours and stuff.
We can continue to have those conversations in between meetings.
And then also I'd be curious if there's any, because I get what we're trying to do, but if there's any way to change the wording that would, satisfy some of the
I'd like to
concerns.
hear, because we have our police chief, do we have any citations that were written for people riding their bike or walking through the park?
It doesn't seem so. Chief Eddington sent a number of arrest files that are coded for the parks. And at least it seems from 2019 to present, it doesn't seem like folks were arrested. And I want to note, the other day, as I was preparing for this, I went to Fountain Square and along the lakefront around 10:30, and I just sat there until about 11 when I removed myself as best as I could from legal liability of being in a park. But for example, Fountain Square is buzzing at 11 o'clock at night, 11:30 at night, sometimes even 12 o'clock at night. I haven't really been there past then. And police drive by and they look at all the people sitting in the park, which is illegal, and they do nothing, which is what I want. And again, people along the lakefront are walking along the lakefront, going home, doing whatever they're doing, and that's perfectly fine. And again, people aren't being arrested, so let's create a law that makes it very clear what you can and can't do in a park, so we don't have situations where laws are unequally enforced, particularly against people of color.
Mr. Chairman, and to answer the question about the numbers being arrested, I think we gathered up some of that data last time for the committee. All the interactions we had at the parks were a call for service. We're only going when somebody calls us. And I think your experience at Fountain Square, my experience nightly at Fountain Square, we're not going to interact unless there's a problem or there's a complaint. And so I am terribly concerned about creating a situation where we're at least giving the appearance of unequal enforcement, in that now you want to put us in a position where saying, hey, we got a complaint, we can hear you, you got to go, and now we're going to have the discussion about, well, what about those people? Well, they're not making noise yet. And I think that we're creating a difficulty that we can avoid by making a rule, hey, the park's closed, move along. And once again, when we have those interactions, nobody gets arrested. You say, hey, you got to go, and they go, we're done. And you can see by our demeanor vis-a-vis the lakefront, vis-a-vis Fountain Square, we're not looking for those interactions. We're not looking to make arrests. But I think that with this clear, bright line rule, we have something to fall back on if there's a complaint that we need to address.
Yeah, thank you. And I would say that there's still a very clear, bright line rule that if someone's making noise that's audible, they have to leave. And what I will also say is that by creating this situation where we're not enforcing a law and we're literally having officers drive by and watch people break the law and not enforce it, I think that creates a situation. And the fact that you say that you only respond to calls, I think shows why this is a perfectly fine ordinance that wouldn't change the status quo at all, because if you're only responding to calls, you're likely not responding to a call where someone's just saying, hey, there's somebody in the park at night. You're responding to a call that somebody is violating an already existing ordinance, that, either they're making too much noise or they are doing something else illegal, which prompted the call, and then that's how you deal with it based on whatever you were called for.
Sir, if I may, I think that the parks, along Brummel, and we've got a bunch of those with tot lots, we get calls for those where people are hanging in the park, and we shush them away. The citizen who call's happy, nobody gets arrested, but we do get those calls for service, and I think that for a minor interaction like that,
If I can interject, just because of time, and I want to thank you for bringing up the tot lots in my ward. If we look at Section A, nothing has changed about tot lots. Tot lots still will close, and they close at 9 p.m., so those tot lots in my ward, you can still come. You see anybody sitting in a tot lot at 9 p.m., 9:01 p.m., you can shoo that person out of the tot lot. So this tot lots are still covered under the current ordinance.
and you don't feel that this will cause any confusion in the populace?
No, I think it'll clarify that you need to get out of the parks at 10 o'clock unless you're being quiet.
Okay.
Council Cummings?
Just one question I want to pose to the committee is whether the ordinance addresses individuals who may stay in the park because of, even as quiet as they want to be, because they really don't have any other place to go.
Well,
such as our homeless population.
Yeah, so currently under our code, it's illegal for someone to set up an encampment anywhere on public property. So if someone wants to make an encampment does not mean they're pitching a tent necessarily. It means that they have provisions for living in this area. They would be banned from doing that. And so that would be addressed. And the last thing, if we have the votes to move it forward to council, I'll save this, but there's also a legal argument about why this is unlawful. And there's a Chicago case that started in 2011. If you need me to go through that, or if you're fine moving this forward to council, we can just move it forward to council and we can have that discussion a later time. If not, I think this is mandated by state law, and that's also why I brought this up. If you want to hear about that now, happy to. So are you fine moving this forward to council?
I'm not sure if I'm going to necessarily vote yes at council, but I'm fine getting it out of committee, so yeah.
Okay, so then all those.
I'm just, I'm there too on certain parts of this, and I'll talk to Councilman Reed about that.
So I can understand better.
Getting it forward.
So what I'm trying to understand is, are we sending to council the ordinance as it is right now.
The ordinance as it is with amendments that Councilmember Herrick has made.
Okay, so what I also heard was cycling through, walking through, but the ordinance that is amended does say remain in parks for the duration of time. So I just want to make sure what the amendment that would be going to council would be. Is that going through the parks or remaining in the parks?
It says, no person shall remain in or enter a public park other than to sit, walk, or jog or cycle. I'm sorry. No person shall remain or enter a park other than to sit, walk, jog, or cycle.
Does it say quietly? Because I remember.
Quietly, yes.
Right, that needs
Quietly.
to be in there.
And that's in there.
All right.
So in this case, they are remaining in the park quietly, but not going through the park.
With this, yes, with this version, and that could change depending on what happens between now and council, or at council, I'm sorry.
And as it stands now, the time would be 10 o'clock and not 11.
So are you advocating that we move it to 11 as opposed to 10?
So I'm advocating that you all vote no for the parks being open 24 hours. That's what I'm advocating for.
The 10
And so, hold on, if I can just ask. So many cities across our state, including Skokie and other places, have law. Ann Arbor, Michigan, a well-respected city, have laws that mirror this. You think those are bad ordinances?
I think for Evanston, I think what we have, there's some language that can be moved around, but it still says remain in the park. I am concerned because you're
It says
talking
shall
about
not.
Other than.
No, it says no person shall remain in a park other than. Yeah.
Other than. So you can remain for those reasons. So my point is, just as Mr. Cummings said, it may not be an encampment, but what are you saying about a person who is coming every night to pretty much live in the park? It doesn't address that.
It does, because we have an ordinance about encampments.
I wasn't able to find that. That's why I
Okay.
just sent you a text message.
Okay.
So I think, but then if we're moving it, if it does vote, I'm trying to just get clarification as to if it's moving forward with the 10 o'clock language or the 11 o'clock.
So are you recommending the 11 o'clock language?
Neither. I'm just getting clarification as to which it's moving
It's going to move forward. Right now, yeah, the 10 o'clock language.
You said there's already something with a special permit, the activity going on as a special
We do.
permit. I mean, as you suggested, making an exception. For
Yeah,
those.
so then I move to amend this to allow exceptions as granted by the Parks and Rec director. So that would allow you to make those exceptions for those folks who, and so that would come at the end of section C. It would say, except, Nick, I trust you, except those folks who are authorized by the Parks and Rec Department Director. Okay, so with that amendment, and then this is motion to move forward to council. What I would really love for, as this moves forward, for the law department, I will send the case over. There's a Chicago case about closing parks that made it very clear that you can only close parks, that there needs to be a significant government interest if you're going to limit folks' ability to enter a public park. And so I'll send it over to you, but I'd love a legal analysis on that, because I think that more so than any of the other values about, whether people can walk and remain quiet, I think that will legally make it very clear that it is, it potentially puts this at legal liability and a constitutional violation to limit the right of folks to enter a public outdoor space like a park without a compelling government interest that is narrowly tailored. And we'll talk about that, why it's freedom of speech and freedom to gather.
I really want to read that because the city is allowed to limit the time.
Chicago is allowed, and they won in that case, but it's only because Chicago claimed that in those hours between 11 and 6, just like our ordinance, that they maintain their parks. And so they argued that they send staff out, which is questionable, to maintain the parks, and that's why they need the parks cleared. Because they provide maintenance. And as our Parks and Rec director has previously disclosed, we do not engage in any kind of activity from staff in parks overnight. So I'll send the stuff to you, and we'll
Yes.
see this before council. But I'd love an analysis on that as well. Okay, so with that, all those in favor? We passed the amendment, yes, right? We passed the amendment that would allow the Parks and Rec Director to grant permits to folks who are operating outside of these hours. So first, to make sure we did that, all those in...
Oh, yeah, go ahead. I'll say what I did
Second,
too
do you
afterwards.
second that?
Yeah, second.
All those in favor?
All right.
Aye. The ayes have it. Go ahead, Councilmember Burns.
No, I was just going to say, I think what that works off of is we're trying to limit or really deny people's ability to access not like indoor public spaces, but outdoor public spaces, not for crimes they are committing, but what we think they may commit. And I think that's with no, what was the term they used in the case you used, with no compelling
government
interest. And I think that, so I'm very curious about that as well. Councilmember Reed shared that with me, but I think that probably is what it gets at. You know, those beaches and lakefronts belong to all of us. And if I want to walk through it and I'm not doing anything, I'm not creating any nuisance or noise or whatever it is, and nobody's trying to clean it, so it doesn't need to rest or breathe or any of that what was stated before, I should be able to do that. And I think that's why it's been, you know, challenged in court. So I'd love to know what you come back with.
I just have two questions. Who was the third vote to pass that amendment?
It was not a roll call vote. It was a voice vote, and the chair determined that the ayes had it. I heard no no's or anything else. So.
Okay.
Okay, and we will. I want to get through one more, and that is the public nudity. Oh, I'm sorry. Yes. Well, we just did. That's. Oh, my apologies. Thank you. Yes. So all those in favor of moving this forward to council, say aye.
What are we talking about now?
The whole ordinance as amended, the parks ordinance.
Oh, okay. I thought we did that. All right.
All those in favor, say aye.
Aye.
All those opposed, any abstentions? One no. All right, the ayes have it, and the motion passes. And then lastly, I want to get through one more, which is Ordinance 50. I move HS 10, Ordinance 57022, Title 9, Chapter 5, Section 11. HS 10. All right, well then,
HS 10 is not long for you?
I don't think HS 10 is going to be long. So, second?
Second.
Second. All right.
And real quick, this is because I'm fine with carrying fireworks over to the next. Well, I actually don't know if we'll have another opportunity.
We can schedule like a whatever meeting, a continuation of
Virtual?
this, a virtual meeting at some point.
No, that's what I was. That's what
Before
I
the
wanted
4th
this to
of
be
July,
before.
maybe even closer to
Can we
it,
do
so
a
it's more
remote?
relevant. Yeah. Okay, so this is Ordinance 57022, Title 9, Chapter 5, Section 11. So in 2018, the state of Illinois became the 37th state to ratify the ERA, the Equal Rights Amendment, and then Virginia later became the 39th state, or I'm sorry, the 38th state, which triggers constitutional ratification. There's a lot of discussion about whether that's valid or not and whether Congress needs to make rules. But regardless of the federal ERA, in 1970, the state of Illinois adopted an Illinois Equal Rights Amendment. And I read that earlier at the top, but the Equal Rights Amendment of Illinois says that it bars discrimination on the basis of sex and reads as follows. The equal protection of the laws shall not be denied or abridged on account of sex by the state or its units of government and school districts. Courts have determined the rights of suspect classes may only be infringed upon by government for a compelling government interest in a narrowly tailored fashion. In Illinois, I would consider that because we have an equal rights amendment in Illinois, that would make gender a suspect class in Illinois. Okay. And so with that, if this is a suspect class and it has to be a compelling government interest in a narrowly tailored fashion, I would say that we have to remove this law and rely on the Illinois statute, which is 720 ILCS 720, Section 30, which in a gender-neutral fashion provides law enforcement with all the tools they need to address issues of public indecency. And so I will first just ask of each member. Councilmember Burns, do you support the Equal Rights Amendment? It's very simple.
Well, what I will say about this is I think it is probably similar to the parks question. You have to define what, being indecent looks like. Whereas this is very cut and dry. You either can or cannot do it. And so I don't necessarily I don't think the state statute makes it easier to enforce even this, because unless it clearly defines what it means to be indecent.
I'm not saying that state law makes it easier to enforce. What I'm saying is that
you brought it up, so I just wanted to quickly comment on that. But
I said it gives folks the tools that they need in a gender-neutral fashion, in a gender-neutral fashion to deal with this.
Yeah, I mean, I don't think it's yeah, but and yeah, that's all I have to say. But I have no issue with this. I want to hear what other people think. I told you most of this stuff I have no real issues with. So I would want to hear from the rest of the committee.
Sure. Councilmember Revelle, do you support the ERA?
That's not where we want to have our discussion.
Well,
Look how late it is. Let me just go right to the chase, which is, so I did some Googling to see what the court cases are saying about whether communities that make a distinction between what men and women can wear to the beach, whether those are constitutional. The overwhelming majority of courts that have addressed laws banning public female toplessness have upheld their constitutionality. So what's really critical is what is our local community standard, because the cases always refer to that. A federal appeals court, this was just a year or two ago in
was this the 7th?
Ocean Beach, New Jersey. Inherent differences between men and women, which we have come to appreciate, remain cause for celebration, but not for denigration of the members of either sex or for artificial constraints on an individual's opportunity. Laws may, for that reason, acknowledge the physical differences between men and women so long as they are not used as they once were to create or perpetuate the legal, social, and economic inferiority of women. The question is, men and women are not the same with respect to the traditional understanding of what constitutes nudity. And before I could support this, I want to know what Evanston residents as a whole, what is their understanding of what constitutes nudity. I'm not willing to approve this until I know that we've got community support for what this could mean. We'll become the topless beaches of Illinois.
And assuming the cases that were cited are
if I can jump in on that particular issue, is the case that you're citing is from New Jersey, which is not an appellate court. It's not the 7th subdistrict, which impacts Illinois. So their decisions are separate of ours because it's a separate sub-circuit. Is that correct?
It's persuasive and not authoritative, correct?
Persuasive and not authoritative.
I'm not arguing that it rules what we can and can't do here. I'm just citing it as, reflecting a lot of it's similar to other laws in other parts of the other court cases in other parts of the country. So
agreed. And just like if there was a law passed here in Illinois that banned abortion, it would be differently interpreted than the same law in Texas because they have different state laws. They have different interpretations of those state laws. So I just want to be clear. But yes, it is certainly persuasive. It is not mandated that we follow that. And what I want to be clear on is that Illinois has an explicit Equal Rights Amendment. New Jersey does not have an explicit Equal Rights Amendment in the way that Illinois does. So that's one big difference. And also I want to note that there are local cases where this has gone to court in Illinois. And it's gone to, in fact, it went to the 7th sub-circuit here. And so it does have impact here. What I will note is that in the case, it was a Chicago case, which has a law that mirrors our law. The folks who, it was Tagashi, let me get that right, the name, Tagami v. versus City of Chicago. And this Tagami case did not cite the Illinois Constitution as a reason for, this being unconstitutional. What they did cite is the 14th Amendment, which we know the 14th Amendment does not provide gender equality. It provides for race, laws to not be based on race, but it does not explicitly say gender. So the 14th Amendment is, they were looking for a big case to make this legal countrywide, but that did not work. And the state constitution is explicit in the fact that there should be no laws differentiating the sexes. So,
Council Cummings, I would love to get your interpretation on this, your opinion, I should say, on if our current code around this puts us out of alignment with the Illinois Constitution.
So, just two thoughts. First, the ordinance probably should include some more factual findings by the committee and or the city council with respect to the city's local standards in terms of the recitals. That would help put us on some better footing. And also, since gender is considered a suspect class both federally and probably even at the state level with respect to the Constitution, the state Constitution, narrowly tailored would essentially mean that we would have exceptions, for example, breastfeeding. When you have like a public nudity ordinance, I would presume, and it's up to this committee and the city council to outline those factual findings that define the compelling interest that the city has in regulating this behavior, which is why I say that those recitals probably need to be a little more fleshed out.
Could you give me an example?
That's the recitals for the current ordinance, not what we're trying to do. What we're trying to do actually couldn't be challenged. The current ordinance could be.
Yeah, but let's take the current ordinance as let's continue to go down this. What recitals have you seen other cities include?
So, to be perfectly fair, this was passed to my department last week with very little opportunity to delve into it. So we essentially prepared it for the packet and provided it, for committee presentation. The research that we did get a heads up on was with respect to burglary tools, and you have a very comprehensive memo about burglary tools, but not so much when it comes to these items here.
Well, I'd personally be fine with holding this.
Yeah, I'm fine with holding this too.
I think what's important for me is just to be clear is that, again, if we are out of alignment, either because we need to add recitals or we need to just strike this totally with the Illinois Constitution, that's what is motivating me to consider making this change. Absent that, I lean more towards Councilman Ravel that I need to see the community come out and make it clear that they would like our current community standards to change around this issue. So that's where I'm at. And so your research on this matter, Council Cummings, is really important. So I appreciate you taking the time to do that. I'm fine to hold this until we get that information back. And again, I think that will inform whether or not we need to either add recitals to the current code or to strike it altogether, for me.
All right. Is there any other, and I will just say one last thing on this, and then we can begin to close out, is this also creates ambiguity for the trans community. Because I don't think our current ordinance is narrowly tailored, because what is so inherently sexualized about the female body that is not inherently sexualized about the male body? And, how do you define female breast? Well, if you look it up, it means that there are cells within that breast that are mammary cells. And so, for a trans person, who has breasts that comport with the way that female breasts traditionally look, does that count? And I think we just really need to get clear on what this law is, create a law that eliminates ambiguity for trans folks, create a law that is in alignment with the Illinois Constitution, and that's it. So I will entertain a motion to refer this item to to hold this
Table?
item, to table this item to the next gathering of
You
the
can
Human
make
Services
motions
Committee.
instead of thinking committee, so I'll second
Yes,
that.
seconded by Councilmember Burns. All those in favor? Aye. This item is tabled to the next gathering of the Human Services Committee. We still have an agenda with a few items. We will hold these items and reschedule to complete this meeting.
Would you mind going over those for the public that
Yeah,
probably
yeah.
isn't listening, but they'll
Maybe
listen
go
to
back
the
and look at
recording?
this. So the items that we are going to revisit, are folks able to do a virtual meeting either later this week or next week to deal with these items?
I mean, I would appreciate the fireworks before the 4th of July. My request to you, Chair, and you'll recall, I asked if we could move that to the top of the agenda. We did not do that, but I'd like to find a way to quickly go over that in some venue. I don't know if there's if we can move that to council. Can we just? Yeah, can we do it at council? I'm fine having it at council too.
That should be a broader.
Yeah. Okay, let's do that then. All right.
So to understand correctly, the fireworks policy will be going to City Council before the July 4th celebration.
So you could move it and vote it now. You could also, on the 13th, one of you could move to have a special order of business
We
placed on
can,
the 27th.
we'll move it now. And so I move that we, because I think these are both pretty simple, and I'll break it up if not, is that we move HS 13 and HS 9 to council. HS 9 is the portion of the Daily Crime Bulletin that includes the names, addresses of folks who have been.
I'm personally fine with that. I think we've talked about it.
Councilmember Harris is fine with that as well. So we'll move both those items to council. All those in favor?
Aye.
Aye. All those opposed?
For some reason, that's not in the packet.
HS 9 is in the packet. It wouldn't be HS 9 if it wasn't in the packet.
I hear you, but I'm looking at the packet, and I don't have it in the packet.
So there's no memo?
There's no memo on it, but
Yeah,
yeah, it's on the agenda though, HS 9. Okay, so that leaves, we voted on that, so that leaves items HS 5, HS 7, HS 10 is coming back to the committee. All the other ones are coming back with more information. And what has passed tonight to council is the noise ordinance, honorary street name, obedience to police in public places, correct, that went forward. Modification to park hours went forward. And then that is, as well as HS 9. Okay, with that, I'll entertain a motion to adjourn. Well, no, there is business before the committee.
So moved.
Moved by Councilmember Burns, seconded by myself. All those in favor?
Aye.
Aye. The meeting is now adjourned.